Good morning. Can everyone hear me?
Good morning, Judge.
Yes, Your Honor.
Thank you. And thank you. Do we have a court reporter yet? That is a no. Now, before we start, I'm going to say I was contacted this morning by my paralegal who indicated that our court reporting company, that we had sent them a thing that the hearing would be starting at 9, and they sent a confirmation back saying that they would have somebody here at 10. They were informed that the hearing was 9 and that they needed to get somebody here, and we have not heard from them since. So that will leave us with a couple of options, which I will be throwing out to the parties. One option is that we wait until 10 to start the hearing. The other option is that, and we're going to be recording this hearing anyway, that we record the hearing. When the court reporter shows up, they will essentially start taking down at that point everything that's said. And between the 9 and 10 o'clock, we would transcribe that portion of the recording. Because I am not a party to this hearing, I don't want to be the one to just make that decision arbitrarily. So before we go on the record or anything like that, I'm going to ask, do the parties have a preference? Mr. Felber?
I have no objection to any of it. If we want to start at 9 a.m., that's fine.
Mr. Banks, on behalf of Ameren? I apologize.
Ameren, Missouri would like to start at 9, Your Honor.
Thank you. And the commission staff?
Judge, either way is fine with us.
Okay. In that case, I guess we will start at 9 or around 9-ish. And then the court reporter will join us at some point.
Coleman, please leave a message or try me.
Sounds like we have a commissioner joining.
Commissioner Hahn is on as well.
Thank you, Commissioner Hahn. Do I have any other commissioners besides Commissioner Hahn and Commissioner Coleman at this point? Okay, we'll begin in just a minute. It's my intention to start right at 9. Okay, my clock reads 9 o'clock. Let's go on the record. Good morning. Today is October 6, 2023, and the current time is 9 a.m. The commission has set aside this time for a WebEx evidentiary hearing today in the matter of Brett Felber, complainant versus Union Electric Company, doing business as Ameren, Missouri respondent. And this is file number EC-2023-0395. My name is John Clark. I'm the regulatory law judge presiding over this hearing today. At this time, I'm going to ask counsel for the parties to enter their appearance for the record, starting with Mr. Felber. Mr. Felber, you're not counsel, but you are representing yourself. Is that correct?
Yes, Your Honor.
Thank you, Mr. Felber. So, Mr. Felber, pro se, on behalf of Ameren, Missouri.
Kendall Banks, Banks Law LLC, 1824 Shoto Avenue, St. Louis, Missouri, 63103.
Thank you, Mr. Banks. Is there anybody else on behalf of Ameren, Missouri today?
Yes, this is Jermaine Grubbs on behalf of Ameren, Missouri. My business address is 19, pardon me, I think there's some feedback.
Let's see if I can reduce that a little. Try again, please. Okay, I'm not picking you up at all now. Ms. Grubbs, I'm afraid you're still muted. In fact, it appears that everybody is muted. All
My
right.
business, I'm sorry. I was just trying to give my business address, 1901 Shoto Avenue in St. Louis.
Thank you, Ms. Grubbs. On behalf of the commission staff.
Yes, Judge, Jeff Keeble, appearing on behalf of staff of the commission, 200 Madison Street, P.O. Box 360, Jeff City, Missouri 65102.
Thank you, Mr. Keeble. Anybody on behalf of the Office of the Public Counsel? Okay, I hear no one. Let's go over preliminary matters. There are a couple of things that I wanted to go over, and then the parties may have some things that they want to address. I noticed in Mr. Felber's filing yesterday that he indicated some concerns over the issue of property damage and over the issue of what he's calling the unauthorized use of his credit cards, for lack of a better term. And Mr. Felber indicated that he believed that those issues were removed from this complaint. I believe, to clarify, what I indicated was that in regards to the property damage, that the commission could not award him monetary damages in regards to that, but to the extent that that would, and I'm not saying it is or isn't, but to the extent that that would be a violation of the commission's rules, commission order, or et cetera, the commission would be able to hear it at least to that extent. And the same way with the unauthorized credit card use, that is not something which the commission has jurisdiction over what would be criminal or civil liability statutes in regards to that. But to the extent that that would be a violation of any commission rule, order, tariff, or rule subject to the commission's interpretation, the commission heard in regard to that. So, Mr. Felber, I'm going to ask you, because this is your complaint, are those issues in regards to the property damage and the unauthorized credit card use, are those issues that you want the commission to address to the extent that they might be a violation of the commission's, a violation under which the commission would have?
Correct. If you want to do that, that's perfectly fine. The credit card actual amount and everything is actually in litigation, and a police report was filed. I actually have a case number, so I'm not going to discuss anything with the credit card. And I remember when we were talking about that before a couple months ago, you know, whether it was in suit or whatever, it's in lawsuit. I haven't had the paperwork served to Mr. Banks. I'm surprised that he even threw it in there. It was 3 hearings ago that we had discussed that, because I had said, hey, this is in lawsuit. There was another lawsuit that was filed, and my bank, due to the amount, they filed a police report the other day. So eventually the police will be talking with Ameren about that, and I'm not going to discuss that, and he should have known that from the beginning. The property damage, there was the picture of the fence. That's what I posted, because that was what the damage was.
Are you wanting the commission to consider either of those in the regard that they might be a violation?
For violation purposes, sure.
Okay. And that may necessitate you talking about those. And we'll address that when we get to.
Right.
So there, I'm gonna, at this point right now, I'm gonna say, I've noticed we've been joined by the chairman of the commission, Chairman Roop. I believe we also have present, as I've indicated before off the record, Maida Coleman, Commissioner, and Commissioner Kayla Hahn. Do we have any other commissioners on at this point?
Just Commissioner Kokmeyer.
And we have Commissioner Glenn Kolkmeyer on. Well, good morning, commissioners.
Good morning, Judge.
All right, in regards to the, just to go over briefly what the scope of commission complaints are so everybody knows. According to 386390 of the revised statutes of Missouri, a complaint in regards to a commission violation involves any alleged violation of any provision of law subject to the commission's authority, any rule promulgated by the commission, of any utility tariff, or of any order or decision of the commission. So those are the things that constitute a violation of a, or those are the things over which the commission would have jurisdiction in this case. Now, at some point, we will have a court reporter, as I indicated before. At that point, it's my intention to take regular breaks, either as the court reporter needs it, or as the parties may need. I do intend, I foresee this going on most of the day. I do intend to take a lunch break for approximately an hour, as close to noon as is necessary. Now, there are a couple pending motions. Mr. Felber had filed a motion yesterday for restoration of his utility services prior to the utility, or prior to today's hearing, since that was filed yesterday evening. The commission did not consider that at that time, and it is my intent to treat that as a standing request, and I will take it with this case. So that will be determined with the case, along with the summary disposition that is out there. I want to go over briefly so that we all understand what the issues are that are being addressed today, because there seemed to be some confusion as to that. Now, Mr. Felber, it's my understanding that you want to address whether whether Ameren disconnecting your service was a violation. Is that correct?
Yes, Your Honor.
Whether you received proper notice of that disconnection.
Correct, Your Honor.
Whether the payment agreement would be a violation and the way that was handled. Is that correct?
Correct, Your Honor.
Whether or not a medical hardship should have been granted. Is that an issue as well?
Correct, Your Honor.
Whether or not, hold on just a second, I'm taking some notes. Whether or not any amount of the pending arrearage should have been covered by a bankruptcy discharge. Is that correct?
Correct, Your Honor.
The previously mentioned property damage and credit card.
Correct.
Is there anything I've missed?
That's pretty much it.
Okay, so those are the alleged violations that this hearing will be addressing today. Are there any other pending motions that I have not addressed at this point?
No, Your Honor.
I hear none. Let's talk about witnesses and order of questioning, because that is not something that was resolved prior to this. Mr. Felber, it looks like you have 3 witnesses, 4 if you include yourself. Is that correct?
Correct, Your Honor.
Ameren, I don't have in front of me immediately available. How many witnesses do you have today?
1, Your Honor.
I'm sorry?
1, Your Honor.
1?
Yes, Your Honor.
And the staff of the commission, how many witnesses do you have today?
One, Judge, it'd be Ms. Sarah Fontaine.
Now, as far as the order of questioning, Mr. Felber, you bear the burden in this case, so you will be presenting your case first. In regard to who is questioning Mr. Felber's witnesses, it would seem logical to allow Ameren to question Mr. Felber's witnesses first, followed by staff. Is there any objection to that?
No, Your Honor.
No, Your Honor.
No.
Thank you. In regards to Ameren's witnesses, it would seem logical to allow Mr. Felber to question first, followed by staff. Is there any objection to that order of questioning for Ameren's witnesses?
No, Your Honor.
Judge, one question. I assume Ameren's witnesses would be going after Mr. Felber's witnesses?
That is correct.
Okay, thank you.
And my intention was to call Mr. Felber, since he's presenting his case first. Since his case is against Ameren, Ameren goes second, and then staff would present its witness last.
Thank you, Judge.
In regards to staff's witness, Mr. Felber, this is your complaint. Do you want to ask questions of staff's witness first or second?
Second.
Any objection from Ameren?
No, Your Honor.
If at any time I get these confused, I have taken them down, but if any time I call the wrong party to question witnesses, please try and apprise me. Now, there is a lot of confidential information in this case. And Commission Rule 20 CSR 4240-2.135, under that, customer-specific information is generally confidential. However, it's going to be impossible to talk about this case without talking about some of your bills, shut-off notices, other things. You are the holder of your information, Mr. Felber. I would like to, as much as possible, try and keep phone numbers and addresses out of this. So if it becomes necessary for us to talk about those items specifically, I would like to go in camera to do so. Otherwise, I think it would be sufficient to refer to the address in question that the disconnection occurred at as the fluorescent address. I think that should be sufficient. I think we could also refer to that as either the subject property or the property where the disconnection was caused. Mr. Felber, do you have any objection to, since you are the holder of your information, do you have any objection to discussing amounts that would be billed and information relating to the notices and disconnection?
I have no objection to that, as long as, important information like social security numbers are not involved.
Absolutely. If we're getting into any information which you believe ought to be handled in camera, please let me know. That goes for any of the parties. As to anything that you talk about, I'm going to deem you as having waived the confidentiality of that information, okay?
Yes, Your Honor.
Okay. And finally, let me stretch my memory here. There was one other thing that I wanted to discuss. And I may not be able to grasp it, so bear with me just a second. Oh, I can't think of it right now, but maybe it will occur to me. I'm going to allow each of the parties to make a brief opening statement. And it did just occur to me. Because of some of the difficulties we had at the last pre-hearing conference with some profanity that probably should not have been used, normally this would be broadcast live via the commission's website. What we're doing, as I indicated now, is this is being recorded. in case we need to redact any foul language. This hearing will be posted to the commission's website after the hearing. As I indicated, I'm going to allow each of the parties to make a brief opening statement. An opening statement is not a complete list of every piece of evidence with every nuance. It is a summary of what the evidence of what your claim is or defense is, and what it is that you believe the evidence will demonstrate or show to the commission. So these are brief opening statements. You will have an opportunity during your case in chief to present your specific evidence in more granular detail. It is not my intention right now, that may change, but it is not my intention now to order briefs after this hearing. I am of the opinion, at least to a large degree, Mr. Felber has been without power for a fair amount of time now, and it is my belief that in this case, justice delayed is essentially justice denied. So unless an issue becomes apparently complicated enough that I would ask the parties to brief it, I do not intend to order briefs at this time. What I may do in lieu thereof is allow the parties to make a closing statement where they may bring things to my attention that they believe the commission should take special note of. Is that understood?
Yes, Your Honor.
Okay, with that in mind, Mr. Felber, as I indicated, since this is your complaint, you bear the burden in this case of demonstrating to the commission that Ameren has committed what the commission would consider a violation. So with that, I will let you give your opening statement. And just to verify with my paralegal real quick, we are recording, correct? Oh, I see. It says in progress. All right, go ahead, Mr. Felber.
All right. First, I want to apologize for the. I will apologize for the last hearing for the derogatory usage of profanity. It was not my intention. Emotions are high, and I should not use emotions as an excuse towards that. However, I want to thank the commission actually for taking the time out of their day today to sit down. I know we all have things that we have to do and everything. I know we all have busy schedules in our life, and there's other options we could be doing, but I appreciate them being able to be here today. Over the last 5 months, I've sat down trying to resolve issues with Ameren, Missouri. While it hasn't been the best of scenario of any of it, this is what I deal with on a constant basis with Ameren, Missouri. Ameren, Missouri will tell you one thing, and they'll give you another thing. They'll avoid the main topics. While they'll paint a picture that they were good, they really were not good. Anytime you tried to do a dispute, they would say they automatically won. They never gave a chance for that. If you applied for medical hardship, there was simply no response back. There's emails to prove it. Ameren is going to paint a picture to you and try to avoid the main subject of this, which is the payment agreement option. The payment agreements. None of their exhibits that are going to show are anything from their main vendor, Twilio SendGrid. I've even offered to have meetings with Twilio themselves 3 times prior to this, so that way we could clear the air and confusion of it. Council has not responded to me. Nobody's responded beyond that. If you were right in the essence of it, I would think you would want to have that. That being said, Ameren is avoiding that subject, and they are given a list of opinions on how to put things into their coding indexes. None of what they're going to show you suffices an actual document. They're going to tell you it's a pending payment agreement, when in actuality, they code it in as a payment agreement. They're going to mislead you on that. They're going to mislead you on their misrepresentation, so therefore they don't have to follow a rule or a tariff. Meanwhile, when you look at a staff report, you're going to notice there's 2 violations that I'm going to bring up later on. However, the staff of the commission didn't want to mention it, which are crucial as to why services should not have been disconnected. I'm going to paint the picture which surrounds the main topic, which was the illegal disconnection, and you'll be able to see that through the several payment agreements, the call logs that you'll be presented, and more. I appreciate the time.
Thank you, Mr. Felber. Very well spoken.
Thank you.
On behalf of Ameren, Missouri.
And I'm surprised that Mr. Felber was not planning on introducing evidence of the commission taking payments from Ameren illegally and the Ameren bribing the commission and the commission staff. I'm surprised he didn't bring that up in his opening statement, but he chose not to. We will present clear and convincing evidence that we followed all of the applicable statutes, case law, regulations, policies of the commission, and tariffs, and everything was done fit and proper. Thank you for allowing me to present our opening statement.
Thank you, Ameren, Missouri. On behalf of the commission staff.
Yes, Your Honor. I'll be very brief here. If you look at the documents that have been filed in this docket, I have to say that in the 30-plus years I've been doing this, I don't think I've ever seen a personal consumer complaint case with as many filings prior to the hearing as this case. And I mention that simply because I think that has led to some confusion as to what the issues are and what is really subject to the commission jurisdiction. If you look at the staff report that was filed, you'll notice that several items we mentioned in there are not, at least in staff's opinion, subject to the jurisdiction of the commission, and other things may or may not be. But really, when you cut through all the chaff and get down to it, I do agree with something Mr. Felber said during his opening, and that is that the main one or two issues boil down to the payment agreement, which he mentioned, and to the question of whether or not Ameren properly billed Mr. Felber prior to the disconnection. And I think that whether or not there was a payment agreement, in effect, it is really a key question here, because if there was no payment agreement, obviously Ameren couldn't violate the payment agreement if there was none. But like I said, I believe those are really two key questions. All of the questions concerning the payment agreement, the existence of a payment agreement, whether the payment agreement was required to be followed, whether it was followed, all things surrounding the payment agreement. And then just the basic question that is frequently encountered in these customer complaint cases of whether or not the company properly calculated the customer's bill. I think those really are, when you get down to it, those are the two key questions that the commission is going to need to sort through the conflicting evidence and answer. Staff was basically unable to determine, because it was to staff, like I said, there's conflicting evidence. So it's up to the commission to decide, and really all of the ancillary things that were floating around throughout the case in terms of other potential side issues really fade compared to those two main issues. And with that, staff will be presenting its report, the author of the report, as a witness later today, and she will be able to answer questions you may have regarding staff's approach to the preparation of the report. And with that, I'll shut up.
Thank you. I'll inform everyone. We've also been joined by Commissioner Holzman, who is also now present. I have a couple of questions based upon what you said, Mr. Keevil, on behalf of staff. Now, when you said depending on how the commission resolves conflicting evidence, are you referring to evidence in regard to the payment agreement?
Primarily, yes.
Okay. And you indicated there were things that staff did not believe that the commission had jurisdiction over. Were any of the issues I mentioned, which are the billing disconnection, the pre-disconnection notice, the payment agreement, the medical hardship, the bankruptcy, the property damage, and the unauthorized credit card usage, over which of those issues is staff of the opinion that the commission does not have jurisdiction?
Well, it depends on what what you were claiming or seeking as a result. Because if you look at the pleadings, or not the pleadings, the filings that have been made, especially the early ones, a lot of those were talking about criminal matters. The commission doesn't have jurisdiction over criminal matters, in my opinion. The credit card thing, I'm still to this day not entirely sure what that has to do with anything under the commission's jurisdiction, because it seems to me like it's been presented as a case of credit card fraud, and that while it would be improper, but certainly it would not be under the commission's jurisdiction, in my opinion. There's been also a lot of talk about property damage. I'm not sure exactly what the commission can do in the area of property damage. Bankruptcy, commission obviously the commission has jurisdiction over utility billing, but to the extent that someone has, or a company I should say, has violated bankruptcy laws, the commission can't, I don't believe, enforce bankruptcy laws. But they can enforce billing issues as it relates to the utility services. Judge, there were a bunch of them in the. I don't have a list of them right in front of me, but that off the top of my head, those are the ones that I recall specifically that did not seem to be jurisdictional. There's also some questions in the original complaint, and I think in the first amended complaint. I don't know how many amended complaints we've had to this point. Seems like every week we get another one, but the first two sought punitive damages. Commission doesn't have jurisdiction over, or to authority to award punitive damages. It would be nice, but they don't. So that was another example of things that were being sought, which were outside the commission's purview. And let me say also, if I may, that since staff filed this report, this entire case has seen a lot of changes. There are a lot of things. It's kind of been a moving target throughout this case. So what is being sought now, in some respects, may not be what was being sought at the time staff filed this report. So, you know, those items would no longer apply, obviously. But at the time the report was filed, there were areas where relief was sought, which was not within the authority of the commission to award, or things were being raised, like I said, criminal matters, for example, criminal allegations, which were not within the commission's authority to or jurisdiction to oversee. So this has kind of been a tough one to stay on top of, because, like I said, the target keeps changing, or has kept changing. So I'm glad we're going to be done today, hopefully, with the hearing, so we won't have to worry about the target changing anymore.
Thank you. Two things I'm going to say in regard to that. I have multiple times in previous pre-hearing conferences, and I will explain for the purpose of this evidentiary hearing, you said that the commission does not have the authority to grant punitive damages. I would take that a step further. I do not believe the commission has authority to grant monetary damages and the amount of actual monies. I believe that the most that the commission might be able to do would be to order some sort of billing credit if it was directly causative and quantitative. I think it might be able to do that. The second thing I might say is you indicated depending on what outcome I was seeking, and I do not believe the commissioners or myself are seeking any particular outcome. We are here today to listen to the evidence with an open mind and make a determination about whether or not a violation of commission order, rule, tariff, or laws subject to the commission's interpretation. So, but thank you. Thank you for clarifying that. I agree with that to a large extent, as we indicated that the commission would not have authority to rule on any bankruptcy matter except if the commission determined that the bankruptcy did in fact cover that amount of discharge, it would be a billing matter. And the billing matter, as you indicated, would be under the commission's jurisdiction. Okay, given that that was the last opening statement, Mr. Felber, I'm going to allow you to start your case in chief in this case. I am assuming, given that you have exhibits and evidence that you want to enter, that you will be your first witness. Is that correct? I can't hear you. Are you muted?
Correct, Your Honor. Sorry about that.
Okay. All right. Since you are going to be your own witness, generally the way this is done is it's not sort of a puppet show where you ask yourself questions and then answer the questions. Generally, I will allow you to kind of go through in a somewhat narrative fashion, and you will offer your evidence that you would like to show as we go along. Before we do that, I am, however, going to swear you in. So would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes, Your Honor.
Okay. Go ahead, Mr. Felber.
All right, so let me get into my exhibit list here.
Why don't you, you are free to go with, and I have your supplemental exhibit list in front of me. You're
Okay.
free to go about this how you like. It might be most helpful to the commission, perhaps, to go about this chronologically with the events that led up to the disconnection and then what transpired there and after. But you may, it is your case and you may present it as you like.
All right, so the first thing I want everybody to pay attention to, and I think I put it in as two different exhibits, just because I copied it, so that way I didn't have to go back through manually the call logs. If they need to roll it down, is Exhibit 1, and they're on Exhibit 14 for T-Mobile call logs. Now, I have on my phone, I have a dual SIM phone that has 2 lines on it, one for my business, one for my personal. The line that they would call, which shows from T-Mobile 785-969-9988, was a business account. That there shows number 1.
Hold on. Let's identify these exhibits specifically before we start talking about them, because these exhibits are not yet marked. So what I've got is you've got Exhibit 1 as call logs and Exhibit 14 as T-Mobile call logs. So
Correct.
let's see if we can find that. This is going to be the clunky part of doing this via WebEx, is finding these exhibits. So I have this. Is this what you're calling a call log?
Correct, and then there should be a copy that was sent with that shows T-Mobile and a call log from May 1st through the 18th or 19th. It was also in the staff report.
Oh, that was also on the staff report.
Correct. I believe it was marked as B&C or D&C that I sent over.
Okay, so it would be confidential Exhibit B. It looks like confidential exhibit B is 6 pages. Does that include all of those call logs?
It should, yes.
Okay, go ahead, Mr. Felber. And are you wanting me to mark those in particular as complainants exhibit 1 and 14 respectfully?
Yes, Your Honor.
Any objections to the admitting complainants exhibits 1 and 14 onto the hearing record?
No, Your Honor.
Okay, complainants exhibit 1 and 14 are admitted onto the hearing record. Go ahead, Mr. Felber.
And then I guess I just talk about it, or?
Yes, now that it's been admitted, you may talk about it.
So pretty much I have a dual SIM phone. One line is for business, one line is for personal. Of course, you can see on the T-Mobile log 785-969-9988.
Wait. I had said beforehand, these are confidential.
Oh, sorry.
This is customer specific confidential information to the, I mean, if you put it out there, it's out there. You're waiving when you do that.
Okay.
If-
Understandable if it does. I mean, I have people that call me on it all the time, but I'll leave it out. I'll leave out the phone number, but those call logs will exhibit and show, especially one from T-Mobile, the accuracy that there was no phone calls when Ameren states that they said they had called me during dates, and they kept on pushing those dates back. One day it was the 16th, the next time it was the 17th, then they moved it to, it was the 18th. So I went ahead and showed a copy of every call that registered from that phone number from the beginning of the month till the 20th. And the only phone call that registered was me calling Ameren on the 19th to go ahead and talk about asking them what they had done. There was no other phone call. There was no other outreach or anything. Those are accurate records from T-Mobile. They use a 5G tower, which literally a cellular tower pinpoints accuracy, GPS location, time transmission of all records is accurate.
Now I'm looking at this and I'm just going to ask some brief questions for clarification here. We've got 2 of these. I'm assuming exhibit 1 is the one that looks like it is off of a mobile phone. Is that correct?
Correct. Yeah, it was a screenshot, Your Honor.
And the phone with the outgoing or with the arrow going away, those are phone calls made from the phone to another phone, correct?
Correct. If they're going that way, they're outgoing. This way, the left I believe is incoming. Correct.
Okay, so the ones that are not, it looks like there's only one kind of mark. So if they're not marked outgoing, they're incoming. Is that correct?
Correct.
And in regards to exhibit 14, is there a way for me to tell which of those are outgoing and which ones are incoming? I don't see any marks there that would indicate that.
On my call log itself, or T-Mobile?
The T-Mobile one.
Let me get into it.
It looks like there's a couple pages ending with calls on May 18th. One of those is circled.
Yeah.
But I'm going to assume, since that one is circled with an 800 number, was that an outgoing or an incoming?
That was outgoing to Ameren.
And how can you tell?
I made the phone call on my phone.
I say some of these say T-Mobile, and if I look, it says income. Okay, I missed that. That's my fault. All right, go ahead, Mr. Felber.
That would be the distinguishing between those. There was no phone call registered from T-Mobile.
Okay, I'm going to pause for just a second. It appears we have a court reporter. Is that correct? I have a window that says Angie reporter. Angie, are you our court reporter for today?
Hi, yes, I was told it started at 10 a.m., so I logged on at 9:30 and I see everyone's here, so I apologize. I'm not sure what's going on.
Well, we addressed that earlier. We requested a court reporter for 9 o'clock. We received a confirmation back indicating that a court reporter would be available at 10. They were contacted back, the court reporter service, that we would be beginning at 9. We have recorded this thus far, but at this point, if you want to start transcribing, you may go ahead.
Okay, I will. And my screen, I don't know why I was trying to fix it because I thought I was signing on early. My screen is not working correctly, but I'm on here and it has my name so you can see me. I will start now. I apologize for whatever confusion at the office.
And what is your full name, Angie?
Last name is Kelly, Kelly.
All right, thank you. And I'm sorry for the interruption. Mr. Felber, go ahead. We have a court reporter now.
All right. So that being said, that will show that despite what Ameren is claiming they called, they never did reach out to me. They never did start the process because there was no disconnection. Or if there was a disconnection in place, they failed to utilize commission rules by following it. Now they're going to show you a PDF customer call log build that doesn't show any records of when they called, that they were able to go in there manually from message broadcast and put it in, but it's not an accurate call log. They are using any document that Ameren is going to produce to you is something that they are simply stating, this is what what numbers we punch in. It's not a call log. It doesn't show a carrier. None of it. And then do I just move on to the next exhibit?
Judge, were you talking? We're not hearing you, Judge.
Yeah.
I apologize. I muted myself. I said Mr. Felber had asked if he goes on to his next exhibit. Mr. Felber, it's however you want to present your case. As I said, it's kind of a narrative. If you want to tell me what happened, or tell the commission what happened, and as you go along, draw upon your exhibits, we will go about seeing if they are admitted at that time, or
Okay.
or if you want to offer a brief background and just go through the exhibits, that is your prerogative as well.
Okay. I was told prior to, and what happened was technically before this was converted over to a formal hearing, it was an informal complaint. I had submitted those logs. I was under the interpretation, because of the representative that I was talking to with the Public Service Commission, Ameren wanted a copy of them. And as long as we were sending those copies showing to suffice, if I had a phone call log showing it, services would be reestablished. During that time, Ameren played their ghost game. They never responded back to the informal side. So I was kind of given the opportunity to make it go formal based off of what the PSC had recommended to do. And that's when I went to the formal side of things. In addition, Exhibit 2, their caller ID log, which I had called numerous times, that I would like admitted, shows telephone spoofing where the caller ID shows up as Boone County government. It had happened more than one time from Ameren, Missouri. And I brought it.
Hold on just a second. Mr. Felber, are you asking to admit Exhibit 2 onto the record?
Yes, Your Honor.
Any objections to admitting Exhibit 2 onto the hearing record? Okay, Exhibit 2 is admitted onto the hearing record, and you may go ahead and discuss that, Mr. Felber.
So I did receive a phone call back in April showing Boone County government. I brought it to their, I guess, Mrs. Engelbrecht, who works with Ameren, Missouri. And more or less I was given an excuse. Then I received another phone call with Boone County government and I just snapshotted it. I sent it over to Ameren as well. I have email correspondence with that. I was given excuses, and anytime I bring something to their attention, it was an excuse. I'm told, oh, well, that's your provider, not our provider. I would want to, with all the spoofing that goes on, the scams that go on, that we hear about, we hear about it on the news every day. I mean, there's scams now going around where people are whitewashing checks. There's scams of people showing up at doors acting as utility providers. There's scams. Ameren has even stated that, oh, if you get a phone call that says to do a payment, or they represent themselves as this, to call us and inform us of this. I did exactly that. The one thing that Ameren told me, they did nothing to prevent that. As a company that says, hey, report scams to us, I would think there would have been a more proactive search on them trying to resolve an issue and go, resolve it. But instead, it was an excuse to them saying, oh, well, it's your provider. It's not us. I'm not the one that makes the outbound phone calls. It's your system that makes the outbound phone calls. What you have programmed in there, I have a PBX phone. I have PBX phone systems that I could put whatever I want as my caller ID name that it would show up and pop up as. Companies, I would think you would go back to your provider and say, hey, this person's doing this, but there was no proactivity with it. Instead, they want to blame the customer instead of looking into it. Even though they tell you to watch out for scams, or if somebody represents themselves as a government entity. Then I'd like to move on to Exhibit 3, which is
Exhibit 3 says rules, regulations, and tariffs, and I see a rule, I see no tariff, but I assume you were talking about tariff page 144, is that correct?
correct, yes. I want to have those admitted simply because it really goes hand in hand with how the disconnection of the process is. So,
Hold on just a second. I know this is a little monotonous, but
understandable.
any objection to admitting Exhibit 3, Mr. Felber's, and it looks like he's circled and underlined what he believes are the relevant portions of the rules. Any objection to admitting that onto the hearing record as Exhibit 3?
Your Honor.
Is that a no, Mr. Banks?
Yes, Your Honor. No, Your Honor.
Thank you, Mr. Banks. And is there, because there's not a tariff sheet attached to this, is there any objection to the commission taking official notice or administrative notice of Ameren's tariff sheets in this regard, with this particular emphasis on tariff sheet 144?
No, Your Honor.
Okay, Exhibit 3 is admitted onto the hearing record, and the commission is taking administrative notice of Ameren, Missouri's tariffs with an emphasis on tariff sheet 144. Go ahead, Mr. Felber.
So, on those, one thing that I want to point out is they didn't follow the disconnection policy in their own regulations that are written down there. Now, there's another thing that needs to be pointed out, because we've moved to the invention of smart meters. So there's a stipulation that Ameren would usually follow. If you didn't have a smart meter, it was a no-cut Friday. So I would think with having a smart meter, you would update your rules and regulations to that, but there's nothing on there. I know they stated that since AMI meters can be activated over the weekend, well, it doesn't state that in your disconnection policy. It doesn't. By the disconnection policy that's in here, it pretty much says you can't disconnect by the wording of it. You can't disconnect prior to a weekend, and it interprets that you can't get a technician out there. There's nothing in there that says, oh, by law, we can, except for AMI meters, we can do this. We can cut it off, make sure your breakers are in the off position, and then we can turn that back on. That would be something I would think, knowing that we've switched around technology, that Ameren, Missouri would want to follow, or make it not confusing to the customer, because it's not fair to the customer. You're sitting here giving a policy based off of, I guess, your old meters, but you don't have anything in there that rides in with your new AMI meters, in parentheses, etc. But it also shows how they breached the agreement, or, well, violated the payment agreement that was given.
And just to clarify, you're talking about the portion where it says a utility may discontinue service to a residential customer between the hours of 8 a.m. and 4 p.m. Service shall not be disconnected on a day when utility personnel are not available to reconnect the customer's service, or on a day immediately preceding such a day.
Yes, Your Honor, correct. There's nothing in there over, AMI meters are not subject to that policy, because they can, and I would think you would want to have that rule. If it's something that they're following, I would think that you would want to have that rule defined, because it kind of misrepresents itself, because under what it shows, under those rules and regulations, it's not distinguishing AMI meters or regular meters. And then I'll move on to Exhibit 4, which is Ameren's vehicles.
And these are the photographs, is that correct?
Correct, Your Honor.
And just so for the information of the commission, these will be available later to look at. Most of these were provided to me via email yesterday afternoon. And they are, just for reference, pictures of vehicles, one of which is an Ameren truck, and people that are near the fence. Is that correct?
Correct, Your Honor. And I guess with you having that,
Well, let me go ahead and let's mark and see if there are any objections to them. So these photographs of Ameren vehicles and individuals, those are all Exhibit 4, correct?
correct, Your Honor.
Are there any objections to admitting Exhibit 4 onto the hearing record?
Your Honor.
Is that a no, Mr. Banks?
Yes, Your Honor.
And I apologize. I'm having a little difficulty with your audio, and I don't know why.
I'm going to put on a headset, Your Honor.
Okay, I was able to hear.
I'm having trouble with your audio as well, so.
You're having trouble with your audio, Mr. Keeble, or with hearing me?
I'm having trouble hearing Mr. Banks's audio.
Okay. Well, I think he's endeavoring to resolve that. Mr. Keeble, do you have any objection to Exhibit 4?
I don't see the relevance of Exhibit 4, but I don't really have an objection to it.
Well, if you're not making an objection for relevance, Exhibit 4 will be admitted onto the hearing record. Okay, feel free to go ahead and talk about that, Mr. Felber. Mr. Banks, do you want us to wait for you to get a headset before Mr. Felber goes on?
Thank you, Your Honor.
Go ahead, Mr. Felber.
So the relevancy of the vehicles is, of course, one is an Ameren vehicle. However, the second one I'm going to point out is a personal vehicle that is on a premises. I understand what utility easement was. I know where the utility easement is, and they were not on the utility easement. Utility easement does allow you to go to a pad mount. I don't disagree with that or object that. However, that shows they were parked on private property in which they were not on the utility easement of which they are required to follow. It will also show that the one I have in question is is the one with Illinois. Usually, if you work for Ameren, Missouri, or if you are a technician, what company you work for or anything, your vehicle is supposed to mark who you are. So if he's a subcontractor, he should have a stamp on there that or vehicle signage that says he's a subcontractor. He does
And
not.
you're,
He does not have that on his vehicle. That is something that is very common in Missouri, and that is something Ameren, Missouri themselves even states clearly in a lot of their scams that they point out. If you see a vehicle that doesn't resemble or display an Ameren logo, to contact them and report that. They
okay.
allow, so essentially they're following a non-agreement of what they're misrepresenting what they're allowing themselves to do, because I don't know who the person from Illinois is. For all I know, it could be the guy's friend, could be a bystander. How do I know he works for Ameren? I
Okay,
don't know.
2 points of clarification,
Yeah.
Mr. Felber, and just for the commission's information, you are talking about a gray VW car with Illinois plates, is that correct?
Yes, Your Honor.
And in regards to the vehicles being parked on private property, is that your private property?
That is the property of the Hazelwood School District.
Okay, all right. Thank you for clarifying that. Go ahead.
Uh, Next, we'll go on to Exhibit 5, which is the property damage to the fence.
And is that the same photos or is that something else?
There should have been a photo with it. Or due to the size, I believe it might have gone through Google Drive. And I made Mr. Banks, because of the size on some of them, they had to go to just one party. I believe I had a kickback. It is an EFS as well, too.
It is. Do you know what EFS number?
Offhand? No.
Can you describe it to me, please?
So it was the chain link bar where the representative was first originally, when they actually came up to our fence line and they said they were going to disconnect our services, and services were already disconnected. So he was attempting to jump the yard. If my dogs could talk, I would have them as witnesses, but they can't. My dogs were barking at him, and that's when my wife had said that the services are already off. So then
Uh,
he immediately took himself off the fence, and during that, I don't know why, but damaged the property of the fence.
Okay, I see in here, at least in the pictures provided, that would be Exhibit 3. Does Exhibit 3 show the damage to the fence as well?
Correct. Yes, Your Honor.
And which picture? It looks like there's one next to a stump where it looks like the top fence post has been dented, and
No,
there's a different portion where it looks like it has merely been bent down a little bit.
That one with the vehicles, if they're parked over, that was my neighbor's property.
Okay, so that's your neighbor's fence?
That was my neighbor. The one you're looking at, is that a rusted fence line?
Correct.
No, that's my neighbor's fence. They didn't.
Okay, so none of those show the property damage you're alleging.
Correct.
All right, so. Ameren, do you have a copy of Exhibit 4?
I don't have it, Your Honor.
Now, you indicated, Mr. Felber, that it was an EFS,
Correct. It is an EFS.
but you don't know, do you know when about you filed it?
It would have been filed June 15th or June 16th, the whereabouts of that.
Okay, hold on just a second, bear with me.
Your Honor, you may want to try EFS item number 49.
Yeah.
Okay, there's a number of images there. All right, that's one.
Yeah, I don't know. It was sent through.
No, I can see, I'm trying to find, oh, okay, I see what you were talking about. That is, and that is what you're calling Exhibit 4, and that is the non-rusted fence that is bent. Is that correct?
Correct. Yes, Your Honor.
Okay, any objection to admitting, I'm sorry, that's Exhibit 5. Any objection to admitting Exhibit 5 onto the hearing record?
No, Your Honor.
Exhibit 5. And let me make a note so I can actually pull it up later. Okay. All right, Exhibit 5 is admitted onto the hearing record. Go ahead.
Number 6 is a picture of the technicians.
Is that from that same date?
Yes, Your Honor. Yeah, everything that I had sent through that, it was sent through Google Drive. It bounced back on your email because I have the email right here. Mr. Banks would have had to open it in Google Drive because of the size. It would not send in a regular email.
How many photos is Exhibit 6?
Exhibit 6 is the one, but it can go hand in hand with Exhibit 7, which shows the technicians without identification.
Okay, I see the one of them walking next to the rusted fence. I see them with binoculars on the other side of the fence. I see the bent fence, which is Exhibit 5. I see a close-up of the vehicle. And then some emails. So which one of it is it the one of them standing, one of them walking towards each other next to the fence? Is that the one you're referencing?
Correct, Your Honor.
Okay. Any objections to admitting Exhibit 6 or Exhibit 7 onto the hearing record?
No, Your Honor.
Exhibit 6 and Exhibit 7 are admitted onto the hearing record. Go ahead, Mr. Felber.
So that being said, again, Ameren says, oh, well, we don't send representatives out unless they have proper documentation. They're wearing a lanyard with a badge that shows who they work for. Both of these representatives are not, despite having an Ameren hard hat and despite having a vest. Anybody can buy a vest. Anybody can make a hard hat. Now, am I questioning the one technician? No, I'm not. I'm questioning the other technician. The problem with it is again, it's misleading because Ameren is a company that says, don't open your door, ask for proof of who they work for. I did ask for proof of who they worked for, and they said it was none of my business. I do have a video recording of the one technician yelling at me, but again, it is a big file, and that is why I did not upload it. That being said, I did ask for identification. The one that has the mustache said that's not important. I need to let the guy do his job. I didn't interfere with him from doing his job. I had told him simply that services were already disrupted. When they came up to my fence line originally, they actually spoke to my wife. And they told my wife that service was being disconnected. And she goes, service is already disconnected, so there's no point in you being here. Now, Ameren's going to claim fraud, but there was no fraud. I counsel the reason why they sent these representatives out is, to be fair, I sent him a picture of a Christmas tree that was working because I had the house hooked up to a generator. So whether he constituted that as fraud, I don't know. They had no reason to be on the property, near a pad mount, or anything of that nature. And I hate bringing this up. I've had problems with Ameren like this before in the past. This goes back a long time. This goes all the way back to 2011, when I had service with them prior in 2011. These are the same tactics that they try to do. They try to say, oh, well, you're going to commit fraud. I have never committed fraud against Ameren, Missouri. These are tactics of what they do to try to get you to drop a complaint or not carrying on with a complaint. And as early as last year as well, too, I know it's irrelevant to the case. They committed property damage to another premises of mine that I have a business in, and they were ordered twice to restore services for not following rules, regulations, and tariffs. But anyway, back to this. This will show they weren't wearing proper identification. You know, for a company that proactivates themselves as watch out for scams, I think it's more than relevant because they're not doing their duty of what they're supposed to do. You know, it's almost as if they're trying to exempt themselves for those rules that they tell people to watch out for. I mean, now the proper thing to do would be to park your vehicle on a street, knock on the door, and say, "Hey, I need to access whatever." Not try to jump a fence when dogs are out there that have a beware of dog sign out there and go from there. But
To clarify, while you're saying that the fence was damaged, nobody actually penetrated on your property. Is that correct?
he stepped onto the fence and then jumped back over once he saw the dogs.
Okay, thank you. Go ahead.
I'm not sure if the reaction, my dogs are very territorial. The one loves to run the fence line, and if I were to jump the fence, he would bite my shoes, just as because it's a protection. I have 2 herding dogs, not herding, but I have a Catahoula and an Aussie. Very good dogs, but very protective too. Then that would lead to Exhibit 7, which shows the technicians up closer that shows they were not wearing a badge of any sort.
Okay, and that exhibit has already been admitted onto the hearing record.
Okay. Then we'll move on to Exhibit 8, which is the payment agreement in JPEG.
Okay. Now is that the one that looks like it was taken from a mobile phone?
Correct. I took a snapshot of it, and I had actually sent that directly to Mr. Banks and Miss Grubbs prior to sending it into EFIS.
And it was filed in EFIS on June 20th of 23?
Yes, Your Honor. And pretty much.
Well, wait, let me, in regard to that, any objections to admitting the payment agreement image or JPEG onto the hearing record?
Objection, Your Honor.
Okay, what is your objection, Mr. Bank?
No objection, Your Honor.
Oh, I apologize. All right, Exhibit 8 is admitted onto the hearing record. Go ahead, Mr. Felber.
So this one is where, and this was one I even emailed to the staff. And it's one of those things of, I went back through my emails. I save emails. I have emails from 7 years ago. I pretty much save everything. And I was going through there and I went through to find what was going on with everything. And I just browsed down and I'm like, wait a minute here. I'm like, this is my payment agreement. I go, here we go. So I'm going to send it over to Ameren to show that there was a payment agreement in place, which showed those dates. I got some sort of excuse from them. That came directly from Ameren. There's there's no denying it. That's their email that they have set up, whether SendGrid sends it out or whatever. That's their own words. That's not my words. That's what they put in. You'll notice it says payment agreement, not pending payment agreement. So that's where their confusion comes in. They tried to say that it was an altered image. Well, unfortunately, JPEGs can't be altered because they're made of pixels. So they tried to say a software engineer looked at it, but I have concerns that they didn't have a software engineer look at it, because any software engineer would realize You can't alter a JPEG form image because it's just pixels. It's not data given. It's not encoded as words. So I did that as a protection and sent that. And I want that.
Hold on just a second, Mr. Felber, and just to kind of go on for clarification for the commission. The email says, your payment agreement has been established. A payment agreement has been established for your Ameren, Missouri account ending in blank, blank, blank. I'm not going to put the numbers in. Your required payment of blank is due by 5/22/23. In order to activate this agreement, here is the details of your agreement. Amount deferred, and then there's amount, a required payment, and then there's that required payment listed. The required payment due date of 5/22/23, the number of monthly installments, which is 12, and a monthly installment amount. And it says your account will be updated when the required payment has been received. Failure to pay the full required payment amount by the due date may result in disconnection of service. Once the agreement is activated, the monthly installment amount will be included in your total amount due each month. A confirmation letter will be mailed to you for your records. Please note, late, partial, or missed payments will result in the cancellation of the agreement, at which time the entire remaining balance of your agreement will become due immediately. Did I represent that correctly, Mr. Felber?
Yes, Your Honor.
And you received that via email on May the 18th of 2023, is that correct?
Yes, Your Honor.
And hold on a second, I had one more question in regard to that, beyond what I'm going to possibly ask about it later. You did not in any way alter the dates on this, did you?
Absolutely not. I would never do that.
Okay, go ahead, Mr. Felber.
So I sent that over to them to explain that.
Oh,
That
I
was-
wanted to clarify one additional thing, and I apologize for interrupting. Just because we haven't covered this, when did you contact Ameren about making this payment agreement?
I contacted them on May the 8th. Would have been the 18th or something. May the 18th.
Okay, and when was your service disconnected?
May 19th, Your Honor.
And just around, do you know around what time?
Around 8:05 a.m.
Okay, thank you. Go ahead.
And so I did. I submitted it to the respondents, in which they stated that it was not an agreement or whatever. Going from there, I asked them actually for a copy when I talked to Mrs. Kirschmeyer. I had actually talked to her before when the here. Okay, so it was filed. It was put to informal on the 23rd, and that Friday, the Friday before Memorial Day, she was in until 12 o'clock. I had talked to Mrs. Kirschmeyer about it, and I said, well, show me the payment agreement. And she goes, I will. And she never sent me a payment agreement or anything of that nature. And that being said, I sent that to Mr. Banks on the 20th or around there. I sent that via email. I could probably look it up. But that being said, one thing I want to point out there, where in it does it say the 19th, the 18th that it's due? And something to clarify is it should probably, if you're wording things towards it's crucial to somebody that their service is going to be disconnected, you should probably put that your services are subject to interruption if it's not made by this date. And it's not a payment. And the difference between payment agreement and pending payment, and here's where they're trying to find that loophole. If they say the word payment agreement, you have to follow commission rules and send out a disconnect letter. You have to send out, so you have to restart that whole process all over again, even though it says they have up to 30 days. If they put that as a pending payment agreement, they do not, because then they're, from what I gather from them, they are simply just adding on days, and you're subject then to service to the next day. So it's kind of a bait and switch and a misrepresentation of that. However, we won't be able to go to the May 22nd date because I wasn't able to, I had to go out and buy a generator. That would be that, though. And I'll move on to Exhibit 9.
Okay, and that is payment agreement watermark.
Correct. And this is where we had a lot of pushback. And I did submit a video over that as an exhibit. Again, I sent it to Mr. Banks last night because it went through Google Drive. I even sent a copy to my wife. But pretty much, many people don't realize if they drop down on their own printers that they have, you can put a watermark on something. A watermark is not a form of altering a document simply because you're not going into the document, you're not going into the wording, you're not going into any of that. You're simply putting something there that translucents and makes the document authentic. So you're keeping it in its preserved original state. So pretty much I put that on there and I put it over to where it can't be altered. Therefore, it can't be because he wasn't satisfied with the JPEG form. So that is why I put the watermark copy of it. I use watermarks every day in contracts. I do high volume contracts for government entities all the time. And trust me, they work wonders if you ever have to bring it to court because that's what they look at. That being said, I would think you would look at it as somebody's trying to preserve a document. However, we're getting the argument of pushback because we're being told it's alteration.
And for clarification, when we're talking about this Exhibit 9, we're talking about the email confirmation of payment agreement where it says across the amounts and the 5/22 dates, Ameren lied. Is that correct?
Correct.
Okay, go on, Mr. Felber.
And I apologize if I put Ameren lied in there and if you wanted something else, but the whole thing of it is they did. They haven't been, again, this proves, so they weren't happy. And staff even said they couldn't verify the JPEG. That's what the staff said in their report. However, by sending that over, I would think you would say, hey, well, Mr. Felber, technically, it's not a PDF that comes to you. Technically, it just comes listed in the way that the JPEG would be. So you would go down there. So I actually had to, when I saved the page, I just did it as PDF and I was able to put the watermark in it. I was able to put the watermark across it and everything. Technically,
okay, hold on. This is the part where I ask Ameren if they have any objections to admitting the watermark payment agreement onto the hearing record.
Yes, Your Honor. The only thing that this exhibit does is it points out Mr. Felber's functionality in terms of manipulating documents.
it doesn't though.
Hold on, Mr. Felber. And so you're objecting to admitting it onto the hearing record?
Yes, Your Honor.
Okay, I'm going to overrule that objection. I'm going to admit it onto the hearing record. And in regard to the watermark, you've made your case as to why you're objecting to this, and that will go appropriately to the weight that should be given the document. So over objection, exhibit number 9 is admitted onto the hearing record. Go on, Mr. Felber.
Let's go on to Exhibit 10. That is the payment agreement, Sengrid Twilio. So,
And this is the same payment agreement that was just shown with the watermark, and it has the attached email response. Is that correct?
from Sengrid, I have two. One from one of their engineers. The next one, Exhibit 11, would be payment agreement with Twilio's receipt showing from Twilio.
Okay, oh, hold on, I see one. Is what I have. Okay, so I've got one that is in what appears to be an unadulterated payment agreement with no response. Is that one of the ones you're referring to?
That's the one that just had SendGrid. Yeah, there should be another one in there that shows, and it was even uploaded to EFIS as well, but it was sent over, the one with the bottom page showing the representative I talked to with Twilio.
Okay, which one is Exhibit 10?
Exhibit 10 would be the one that just has no reply Twilio attached into it.
Thank you. And the other one would be Exhibit 11?
Correct, Your Honor. Yes, sir.
Okay, go ahead. Well, let me ask, hold on just a second. Any objection to admitting Exhibit 10, confirmation of payment agreement with no response onto the hearing record?
No, Your Honor.
Exhibit 10 is admitted onto the hearing record. Any objections to admitting Exhibit 11 onto the hearing record?
No, Your Honor.
Exhibit 11 is admitted onto the hearing record, and that is the payment agreement with the response from, is it Nigel? Is that correct?
Correct, Your Honor.
Okay, Exhibit 11 is admitted onto the hearing record. Go ahead, Mr. Felber.
So pretty much, Ameren utilizes a company called SendGrid. Their parent company is Twilio, where everything comes out from. Ameren implied, and the reason it took so long for me to get is because Ameren admitted in the staff report that they could not get a copy, and that was when we had the JPEG copy, I believe, and that was submitted and watermarked. They stated in the staff report right in there, the one page that says SendGrid does. SendGrid does things to a matter of a fact. There's a fine line where you have to follow a procedure, and everybody has to follow a procedure to get. And it was really conclusively it's up to SendGrid if they want to give it to you or if they don't want to give it to you. And you have to follow the process. A certified mailed them. I said what was going on. I left it as that. And I said, hey, I really need these documents because this will prove what's going on with my matter. I didn't get into specifics about the case or anything of that nature. That being said, I went ahead and I was surprised I got a copy, so I submitted it up. Then after that, again, we got pushback off of it because the watermarking and everything, the preservation. And so then I had reached out to their software engineer department, and on Friday the 22nd, I believe, or 23rd, whatever day that is, I got a response back. And they were able to verify it. Now, like technically, should I have given that to you guys? I should not have, because I have to, anybody that's wanting to transcribe that would still have to follow the process of being able to obtain it. Technically, that is my copy and what I asked for. So if Mr. Binks wanted a copy, he could simply follow the process and send whatever he needs to over, mail it to him, and they could request it or not. Does SendGrid get rid of their documents fully? Absolutely not. They have a server that does keep documents. Yeah, it's pretty far deep, and you need a very good reasoning why, but they are willing to help out in any way that they can.
Okay.
And I know the reason he doesn't want it admitted is because of the fact that the matter is, it agrees with the subject verb of my foundation that they did not utilize and properly do the payment agreement. That's why he doesn't want it done.
He didn't object to the admission of either Exhibit 10 or 11.
Right. Well, the first exhibit he wanted to he didn't want in. I have no, as a person, and let me just clarify, as a person that works in the cellular industry and data communications industry, I would never manipulate something or change something to benefit. That's not how I work. I'm a very respectable person. People come to me when they need data retrieval. You know why they come to me? Because I carry a master subscription. I can run every document through, and I can tell you by my software if you've given me a valid document and not. And then on top of that, one thing I want to point out, if he had a software engineer actually look at that, each corner has an encryption code in it. I'm not going to give that encryption code, and it's invisible. And the only reason I did that, because he said a software engineer. Any software engineer would have found it. But I did that to protect and preserve the item. That was simply it.
Okay, well, it has been, those Exhibit 10 and 11 have been admitted onto the hearing record.
All right, number 12 would be, I named it as utilization documents of how to code.
And is that the ones that are send SMS with Twilio programmable messaging?
Correct. Yeah, there's a whole bunch of things.
There were about 5 of them corresponding to different kinds of coding, I believe.
Correct.
Okay.
Yes, SendGrid gave me those, and that was one of their things they wanted to show.
And that's Exhibit 12?
Yes, Your Honor. That is how everything is key coded in, and how they utilize, whether they use Python, C+, any of their software utilization programs. Because there was
Okay,
one.
hold on, Mr. Felber. Any objection to admitting Exhibit 12 onto the hearing record?
Yes, Your Honor. Lack of foundation, irrelevant, immaterial.
Okay. Well, in regard to foundation, and the same rules apply to you that would apply to any attorney, Mr. Felber, how did you come across this?
How did I come across it? I was given it from SendGrid, because that is how the system is utilized and how they put things in. So in a document
Okay, hold on. You're wanting to talk about the document. We're still addressing the objection.
Okay.
What is the purpose of this exhibit?
This will show, however, that this shows how they key code in everything to make the system work. So whatever system to utilize, whether it's Python, C+, everything that's there, that is how they would encode it if they were to send out a message.
Why is this important to me? What can I get out of this document?
Out of it, it would, it kind of goes hand in.
Why is it relevant to this case?
It's relevant to the case because in a document that Mrs. Kirschmeyer gave, they left out a crucial email address of their own email address in the payment agreement that they say they wrote. They put my email address in it, but they didn't put theirs. And the one that they're going to present.
Hold on. And let's just go to one of these. Let's go to page 3 of one of these where it says, I believe a little ways down, at client messages. Is that what you're talking about?
Correct, yes.
So you're saying there is a place for them to put, that there is a place for them to put their email that must be coded in. Is that what you're saying?
Yes, Your Honor.
Here's what we're going to do with this Exhibit 12. Because this Exhibit 12 is responsive to because this Exhibit 12 is responsive directly to an Ameren, Missouri exhibit, I am going to hold ruling on, I'm going to withhold ruling on its admission now until we get to Ameren's exhibit that this is responsive to. And we will address the admission of Exhibit 12 at that time. Because right now, it doesn't really mean a lot to me. I understand why you're trying to get it in, but perhaps perhaps that will change when we get to Ameren's exhibit.
All right, thank you,
So
Your Honor.
let's skip over that for now,
Okay.
and I will highlight so that I remember to come back to that. All right, so that's not admitted at this point. Go on to
Understandable.
Exhibit 13.
Yes, Your Honor. That would be staff report.
And, hold on one second. Just to reinforce my memory, Mr. Banks, will you remind me of this objection when it gets to the relevant time period?
Yes, Your Honor.
Thank you very much. All right, go ahead. Exhibit 13, that is the staff report contradictions, where you have taken a couple of pages of staff's report. Is that correct?
Correct.
I am wondering at this point in regards to staff's report, since they are going to be asking to admit their entire report and memorandum, which is Staff Exhibit 200, if rather than having multiple copies of incomplete portions of the report, if it would be better to address admitting Staff Exhibit number 200, the staff report, cover pleading, staff report, and memorandum onto the hearing record. Do you have any objection to doing it that way, Mr. Felber?
I do not.
Okay. Ameren, Missouri, do you have any objection to doing it that way?
No, Your Honor.
And staff, do you have any objection to going ahead and admitting your staff report, cover pleading, staff report, memorandum, staff exhibit 200 onto the hearing record?
I don't object to that, Judge, but I would also, since you're doing that, I would ask that you include the attachments, or maybe you are, but include the attachments to the staff report, because I gave them sort of different exhibit numbers by labeling them 200A,
I see that.
200C.
Okay. I don't want to jump over or prevent anyone from objecting. I just think it's better to have a complete document as opposed to an incomplete document entered into the record, especially when we have when the incomplete document is a portion of a complete document that is evidence of another party. So I'll ask you again, Mr. Felber, have you had an opportunity to look at staff's exhibit 200 and 200A, B, C, D, E, and F, which are the attached exhibits to that?
Correct.
Do you have any objection to admitting any of those onto the hearing record?
No, I do not, Your Honor.
And Ameren, Missouri, do you have any objection to admitting Exhibit 200 and 200A through F onto the hearing record?
No objection, Your Honor.
And Mr. Keeble, do you have any objection to admitting those onto the hearing record?
No, I was going to move that they be admitted later on anyway.
I understand that, but people may have a time that they want those admitted. And normally, as Mr. Banks had previously pointed out, there is generally a procedure to let them in involving laying a foundation and everything else. So if we are skipping over that, it can only be by agreement of the parties. So hearing that nobody objects to that, I'm going to admit Exhibit 200, public and confidential, onto the hearing record. Exhibits 200A, 200B, 200C, 200D, 200E, and 200F onto the hearing record. So there were no objection to those, and those are all admitted onto the hearing record. So with that in mind, what pages of this do you want me to go to, Mr. Felber?
The staff report?
Yes, and that is, I believe, looks like you have several pages here that you're talking about? You're talking about the report of staff, and it looks like the first 1, 2, 3, 4,
Yeah, there's
5
four.
pages.
Yeah, the first page is just their signature. I don't care about that. I had to put it in when I had to do it when I was doing selective pages. The first page isn't the one that really has the issue because it just shows Mr. Keevil and Mrs. King's signature on it, correct?
Why don't you refer me to where, and I believe, according to your exhibit list, staff report and contradictions which show violations. So what are the contradictions that show the violations?
Down here, well, the number one thing is that when page 8 goes into page 9, and well, hold on, let me go into everything because I have it saved. I know I sent. That's just the exhibit listing.
And just for clarification, exhibit 13
Okay,
is not admitted onto the hearing record since we are admitting staff exhibit 200 and its attachments instead.
I'm waiting for. Okay, so the first page that has report of the staff, I don't need that. It just had to be done. Page 4, which, well,
Give me a starting paragraph.
customer service complaint.
Okay, I see it.
We'll notice in here, and we do have a dispute. That's something I think we conclusively agree on. It says right here under 5, where the commission writes, if a customer disputes a charge, she shall pay the utility amount equal to the part of the charge not in dispute. The amount not in dispute should be mutually determined by the parties. The parties shall consider the customer's prior consumption history, weather variations, the nature of the dispute, and other pertinent factors in determining the amount of the dispute. If the parties are unable to mutually determine the amount of the dispute, the customer shall pay the utility the lesser of an amount not to exceed 50% of the charge in dispute, or an amount based on usage during like a period under similar conditions, which shall the amount not in dispute, which that hasn't even been an option. I have sent over I've sent over payment agreements to them, and they've kind of just walked it off. Now,
Now it says, I'm going to stop you here for just a second. Now it says, you're referring to that paragraph 5, which they pulled from Commission Rule 20 CSR 2420-13.045. And in it says staff's report says that because Mr. Felber and Ameren could not agree on an acceptable amount, staff believes the following rule should apply. Is that correct?
correct. It should apply.
All right.
I would think, and it's nothing against staff. I understand staff has a job to do, but it kind of misleads itself because there hasn't been any reasoning on either side, and I understand that. But if somebody's, I've even tried to go through and will to resolve the issue outside of there, and at this point they want $4,000 something, in which I do have bills that show they've charged me inaccurate usage. All I want is a proper, correct bill.
And this is where the commission, this is where I had some difficulty understanding your original complaint. And I think it had to do with the fact that you were asking for punitive damages, because I believe your initial complaint, the amount at issue you indicated was was an amount far in excess of the amount that Ameren says you owe, correct?
Correct.
And then you amended that in an amended addition to the complaint to make that amount a little more than 50% more. Is that correct?
Correct.
So it was there was no way to determine exactly which portion of your bill you were disputing from your complaint.
I've asked them for copies. They were given a piece of paper 2 months ago. I asked for all ledgers, how they calculated everything, because I had shown two bills. Ameren's usage history only shows so much far back. Should I save more bills? I probably should. But the two bills that I had uploaded to staff showed inaccuracies in which, to date, those haven't been resolved. So it would fall under, I asked for clarification because if they're charging me wrong in a bill, then, then your taxes drop, fees drop, stuff like that. All that I want is an accurate bill. That's all I want. It's all I want in one bit. Any dispute that I've followed with them, they have not reached out to me to try to help resolve the issue. They don't give me anything to do. They say, "Oh, well, we go back over it and this is that." And I think all that they do is prolong it and then they re-go at it and supply it. I had asked.
Why is this? Your says it says it's a contradiction which show violations.
Because
Just explain to me what the contradiction is and what the violations are.
Well, the violations would be under the commission rules and agreement to setting up and both parties agreeing to mutually pay, I would agree to pay 50% of the balance. And then services should have been able to be restored, but it wasn't offered.
And how is that a contradiction?
It's not. I read it wrong. And I apologize, Your Honor, because it says the staff recommends. Sorry.
Okay, no, that's fine. That's fine. Is there anything else you wanted to say about that?
About that part, no.
Okay, go on then. I apologize for interrupting you.
No, it's fine. And then we have the page where it should be, where page 10 of 13.
What is the closest bolded paragraph title?
Ameren sent an agreement in writing to Mr. Felber.
Is that bolded or is that just the first line of the paragraph?
It's the first line of the paragraph, Your Honor.
Okay, hold on just a second while I find it.
It looks like it's the very top of the page, Judge.
Yeah, top of the page. The bankruptcy's below it.
Okay, bankruptcy is below it. There we go. Okay, I guess I am old school in that I look for an indentation to begin a paragraph.
I'm sorry.
And my understanding is that, no, it's not your fault. Conventions have changed and I have not changed with them. So go ahead. Ameren sent an agreement in writing to Mr. Felber,
However, Ameren did not notify Mr. Felber by personal service or first-class mail about his default prior to his disconnection. And in Ameren's response to staff DR 0027, it stated that it has an email template it uses for these confirmation emails. Staff has submitted a data request to the company as of July 21st, 2023, requesting a copy of the template. Without this information, staff cannot determine what is sent to customers in these situations. I would think right.
Go ahead.
I would think right there, that's a key piece right there. That's Ameren admitting they failed to send out a disconnect notice. Now, again, it falls into that fine line where they're saying payment agreement or pending payment agreement. On the agreements that are sent out by Ameren, they say payment agreement. So payment agreement would apply to this. They would have had to send out a disconnect notice, first class mail. This right here admits that Ameren failed to follow commission rules and regulations. There's nothing on the emails sent. I mean, sure, he can argue. I understand you get your arguments of alteration or whatever, but payment agreements, there's no lie or deny it. It's what they key code in for their interpretation of what it is. If it's going to be something of that nature, they should do better wording of how that is done. But right here, it admits they didn't send out a disconnect notice first class mail. And that is one thing that you guys require that's sent out prior to a disconnection.
Okay. Go ahead, Mr. Felber.
Okay, I'm going back in here. Then Exhibit 14 was the T-Mobile call logs.
And that was already admitted.
Already admitted. Exhibit 15, I think, is crucial because of a couple things. First and foremost, I am the type of person when we try to prove something or clear something, I believe in being able to, the whole goal of everything is to mutually come to an agreement, correct? Or resolve an issue without the process of carrying on further and further. So when I got the agreements, I offered for counsel to reach out to me not only once, but 3 times to set up a video conference with Twilio to go ahead and discuss these agreements. So that way they could get a better grasp of how they're done.
Hold on, I need to find this email you're discussing because I do not remember seeing it in your exhibits. Okay, setting up a conference between Twilio respondent and complainant?
Yes, Your Honor.
Okay, and that is Exhibit 15, is that correct?
Yes, Your Honor.
Any objections to admitting Exhibit 15 onto the hearing record?
Yes, Your Honor, irrelevant and immaterial, and by further explanation, as outside counsel for Ameren, Mr. Felber gives me too much credit for my ability to direct people to do and not do anything. However, in this instance, I did direct our people not to meet with Twilio because of matters that would later come out and would probably only further excite the parties for me to go into now.
You said this is crucial, Mr. Felber. Why is this crucial? All this shows to me is that you invited Ameren to meet with Twilio and they declined.
I would think he would want to know for the record of anything that, hey, this is what was sent. This is how the process works. This is how it is, what goes on. Now, he's saying if there's something else that and I understand as counsel, he has his job to do. However, I believe he's going to try to use a tactic that he's not admitting things to.
Well, I think you just indicated that you invited him to interact with you and Twilio, and he indicated that he specifically instructed Ameren employees not to and had no desire to do so himself. I don't see where you need the exhibit once that's been done. That's already part of the record.
Okay.
So, and I actually agree. I agree with Mr. Banks. Outside of the mere fact it's not the content
Okay.
of this exhibit that's important to you. What's important is that you offered and that offer was not accepted,
Not
correct?
accepted. Correct, Your Honor.
I think we've established that. Exhibit number 15 is not admitted onto the hearing record. I am sustaining the objection.
All right. Thank you, Your Honor.
All right, go ahead, Mr. Felber.
Number 16 is the email. Back earlier this year, I remember, again, Miss Engelbrecht and I, Miss Grubbs go back pretty far as talking and stuff. I received a thing for medical hardship. That email that I sent was an email to Mrs. Engelbrecht, which establishes that I did go through the process, and I wanted to know the status of it, and there was no response back. I kept my son's medical records out of that, or medical and everything out of that, simply because. But that establishes where they said I did not apply or did not take an attempt to apply. There's an email correspondence between us that I did apply, and the two people that regularly were, well, she was one of the main working on the account. So it establishes that there was a lack of neglect for them following through to make sure.
Okay. Is there any objection to admitting Exhibit 16, the email to Terry Engelbrecht onto the hearing record?
Yes, Your Honor. This record was provided to us after the close of discovery. It was subject of a motion to compel for further up information, which I don't believe has been ruled on, and it should be stricken as not admissible.
You could argue that, but however,
Hold on, I haven't asked for a response yet, Mr. Felber.
okay, all right.
Did you supply this to Ameren after the close of discovery?
He had badgered me for it because he kept on bringing it up in previous statements.
Well, by badgered, I will go with he had requested it. So he had requested it from you.
Yes, he requested it from me. And then in continued responses that he put in hearings, he continued to label that. So I went ahead and dug it up from my emails and I submitted it to show that I did apply.
Cleaning up a little bit.
I'm picking up somebody's conversation. I don't know who it is, but if we can mute that, I don't want it on the record. Mr. Banks, is there a form that needs to be submitted? Is there a form that is, because it says paperwork?
There is.
Well, I wasn't asking him, I was asking Ameren.
Oh, sorry.
Your Honor, what Ameren requires is a statement faxed to Ameren directly from the medical doctor's office describing why the medical extension is needed and outlining how the patient would be affected adversely if it's not given. It has to be provided before the disconnection, not after the disconnection.
That was in March.
I understand and I can see that. And it says that you're applying for financial help and medical hardship, in which case I would like to apply for. Here's what I'm going to do. Over Ameren, Missouri's objection, I'm going to admit this onto the hearing record for the limited purpose, because it does not indicate that you ever actually submitted any sort of paperwork. I am allowing it for the limited purpose of showing for the limited purpose of showing that you emailed them to get information regarding financial help and a medical and a medical hardship. So, Ameren, your objection is overruled, and the objection is, and Exhibit 16 is admitted onto the hearing record with the limitation that is only to show that he had requested information regarding applications for financial help or medical hardship. Wait a second while I take a note as to that. All right. Did you have anything else you wanted to say about that document, Mr. Felber?
No, Your Honor.
Okay, continue.
Exhibit 17, if you want to admit it or not, it's just there. Missouri state statutes regarding access to a meter or any of that nature.
Any objection to admitting those onto the hearing record?
No, Your Honor.
Judge, I think I am going to throw one out on the statute. I believe, if I'm not mistaken, that statute is referring to multi-residency buildings. You look at the definition of residence, I think it talks about multi-occupancy residence. So I don't think it would have any applicability to this particular situation, which is not a multi-occupancy situation.
Now, does this relate? There were, if I remember right, there were two things in here I saw. There is chapter 393, written demand, notice contends refusal of access. And then you are using the 393.550 definitions in regards to denial of access. Is that what you're trying to get to?
Correct. Denial access, yeah. Access demand notice and everything of that nature.
So you're not wanting the definition of residence there. You are actually wanting the definition of denial of access.
Correct.
Okay.
But Judge, I think that definition only applies when all the other definitions also apply.
So you're saying that denial of access would only apply to a multifamily home?
I could be wrong, but that was my initial impression when I read through it. That particular, because I think what that definition is talking about is a situation where due to one occupant, one occupant is preventing the utility access to the premises, which affects all other occupants. And that particular statute allows the utility to go to circuit court to get a access order when the other occupants don't want to allow access. But this is, again, I don't even see the relevance of this, because it's not a question of was the utility denied access to Mr. Felber's meter. So I'm not even sure how this would factor into this particular case, but that's why I'm a little confused.
I see what you're saying. I see what you're saying, Mr. Cable. I dislike it when residence can mean different things depending on which chapter or section of statute we're in. Why is this important, Mr. Felber? What are you trying? What do these two interacting with each other show? What are you trying to show?
All right. So I guess what I'm trying to show off of it is, I would assume by them when they were up at my fence line and trying to jump my fence, they were trying to get access to the meter itself. Because that would be the first thing you're going to probably do, is you're going to want to yank the meter off. So that way you can have possession of the meter. That being said, I have no problem with you trying to get access to a meter. I have no problem with whatever, but they didn't follow what they're supposed to do and send out an access demand letter, and that would constitute them trying to go into the yard. So then after that, the next thing that they decided to do was go over to the pad mount. It's because if they didn't get access to the meter itself, that would be your next course of access to be able to use, and then go ahead and do whatever you call a soft reset, hard reset, and just do that. However, that points out that Ameren, Missouri did not follow protocol of access demand. They actually loopholed themselves, and instead of parking their vehicle on the street like they should have, ringing a doorbell, or even my neighbor's doorbells, and said, hey, I need access to this or this or this, go from there. And then from that matter, go from there. If they were constituting fraud, as they say, that would play relevant, because usually when you call for grounds of fraud, usually you have a government entity come along with you. I know Spire does the same thing. If they think somebody's committing fraud, they send a police officer. Ameren, Missouri didn't do that. Ameren, Missouri did not want a police officer to be there, simply for the fact of they knew they were encroaching property that they were not supposed to be on. I have no problem with them doing what they're doing, their job. I just want them to do it the legal way, the right way, and go from there. The rules shouldn't exempt them from not following and getting a access demand letter and sending an access demand letter. In fact, under law, since I would be renting from a landlord, they should technically notify my landlord.
Yeah, and I'm sorry for having misspoke.
Go ahead, Mr. Banks. I apologize.
Ameren, Missouri joins in staff's objection.
Well, here's what I'm going to say. I decided this while listening to Mr. Felber talk in conjunction with the law is the law. Whether or not you admit an exhibit on in that regard, it doesn't change the fact that 393-550 through 393-553 exist. So I will, Mr. Felber, keep those in mind and take a further look at those as you have pointed those out to see whether or not I believe that law in any way applies. However, I am not going to admit the exhibit. So Exhibit 17 is not admitted onto the hearing record, but I will take a look at 393-550 through 393-553.
All right. Thank you, Your Honor.
Judge, and I agree. If it applies, it applies, and it should apply. But if it doesn't apply, then it doesn't apply. So,
and that's why I'm not allowing it as an exhibit, but I am pointing out that I will look at it.
Yeah. That was good. Thanks.
Okay. Go ahead, Mr. Felber.
Exhibit 18, and again, if it needs to be entered in, it can be, or it doesn't need to be entered in. It's the definition of the dictionary between alteration and watermark.
Any objection to admitting Exhibit 18 onto the hearing record? I'm sorry?
Yes, Your Honor. Irrelevant, immaterial.
Oh, no.
Hold on, Mr. Felber. Mr. Banks, would you clarify why it's irrelevant and why it's immaterial?
Because it doesn't lend itself to satisfying any of the issues that we're here today to discuss. I can concede that the dictionary says alteration is one thing and watermark is something else, but that's not determinative.
I don't think it's determinative. I think Mr. Felber is asking to get this into the record merely to make a distinction between a watermark and an alteration. I'm going to overrule your objection and allow it in for that purpose. It doesn't seem to be, while it is a Google definition, which I'm not particularly fond of, there's nothing about it that strikes me as particularly different from what I would expect to find in any dictionary in regards to those terms. So I will let it in for that limited purpose and overrule your objection. Go ahead, Mr. Felber.
Then I would have exhibit over two Ameren bills. It would be 19. They were sent. It was a bill for 7/29/2022 and a bill for November 29, 2022.
Any objection to admitting exhibit 19? And that's two bills, is that correct, Mr. Felber?
Yes, Your Honor.
Any objection to admitting exhibit 19 onto the hearing record?
Yes, Your Honor, they're not included on Mr. Felber's exhibit list.
They were.
Well, that is true, actually.
I sent them.
Has Ameren seen these bills before?
Yes, Your Honor.
So Ameren was aware of their existence?
Yes, Your Honor.
What's the purpose of offering these, Mr. Felber?
They were circled and highlighted. If you notice on November 29th's bill, I have charges for summer usage in the winter. Ameren doesn't charge summer usage in the winter.
Hold on. Point this out to me, please. And
Hold
bear in
on.
mind, I haven't ruled on this yet.
On
I'm looking at the 11/29/22.
correct.
Where
If
am
you
I
notice-
looking?
If you notice down on it, it shows where there's should be a circled, or it's not circled on that, but in EFIS it was circled. I'm being charged a small fee for summer usage in the winter.
Hold on just a second.
They're also in the staff report.
Hold on. Now, I believe, and can somebody, I've got a few clarification questions for either Ameren or staff, and it just has to do with a gap in my realm of knowledge. Now, if I'm correct, there is a summer and a winter usage rate, but not a fall or spring usage rate. Is that correct?
Your Honor.
And what is considered summer? What months are considered summer for the purposes of the summer rate? Has staff had an
Yes.
opportunity? Oh, go ahead, Ms. Krebs.
I apologize, Your Honor. It took me a second to get off of mute. The summer rates are in effect from June 1st through September 30th. So this is what we call a straddling bill, if you will, a transitional bill, because it reflected summer and winter
And that's
usage.
because it goes from the 27th, but not the very end of the month. Is that correct?
Yes, Your Honor.
Okay. And in regard to the 7/29/22 bill, Mr. Felber, what do you think is the discrepancy there?
Again, winter and summer months.
Ms. Grubbs, when did you say, and this is being billed for? Ms. Grubbs, when did you say that the summer months apply to? I heard through the end of September, but I didn't see the starting date.
June 1st through the end of September.
So that would also include part of the winter rate, is that correct?
Yes, this is also a seasonal transition or straddling bill.
Does it go through, Your Honor?
Hold on. Can you repeat that again for Mr. Felber? You said June 1st?
Yes, summer rates are in effect from June 1st through September 30th.
Yeah.
I don't think this shows what you think it shows, Mr. Felber. I am going to, over objection, admit it onto the hearing record and give it its due weight.
All right. Thank you, Your Honor.
All right, go ahead.
And the last one, it doesn't have to be admitted. If not, I sent it. It was late last night. I wanted to go ahead. I did a video. I don't think you got it just because it was a Google Drive and how big it was. Mr. Banks did get it and my wife did get it. It was a video document of showing how to utilize watermarks through HP and how my printer comes with the capability to add a watermark. Whether he wants it, whether he uploaded it or not or whatever is up to him. It's too big of a file to send via direct email, but it shows right in a drop-down box for HP watermark, and you just click it and you can put it in. You can put which way you want it. If you want it diagonal, straight across, centered, left, right. I had sent that to show that despite being said that I can change things, I can't change things. It goes to show that I did not do anything to the document, but put a watermark on it. That's all I did.
And this is Exhibit 20?
Yes, Your Honor.
Any
Did you get that, Mr. Banks?
Any objection to admitting Exhibit 20 onto the hearing record?
Yes, Your Honor, it does not contribute to the resolution of the issues. And in fact, we would argue that it makes our case. It proves that he is capable of manipulating these documents, and he gives us a tutorial about how to do it. We don't think that tutorial helps us resolve any of the issues in dispute.
Okay, and then, all right, you're saying it makes your case, but you're objecting to its admission.
That's right.
Okay. I actually agree with Mr. Banks. I don't think it's necessary, and the reason I don't think it's necessary is because the watermark payment agreement has been admitted onto the hearing record. So we already have it. There's no necessity for a video explaining what watermarks are and how they were done. So
Understandable, Your Honor.
So Exhibit 20 is not admitted onto the hearing record and the objection is sustained. Okay. It is still, you are still testifying, Mr. Felber. So this may mark the end of your exhibits. Is there additional testimony that you yourself want to offer at this time?
And testimony of anything or just anything in general?
Not argument. I don't want to hear argument because
Okay.
that's something you should say for closing. But if there are additional facts that is not covered in these evidence that you want the commission to be aware of.
That's pretty much it.
Okay. I don't know about anybody else, but I feel like at this point I need to take a short break. Are there any objections to taking a short recess at this time?
No, Your Honor.
No, Your Honor.
Staff?
All right, Judge, no, I have no objection.
Okay, what I will probably do is I do want to at least get through Mr. Felber as much as possible, assuming we can do that before we break for lunch. So why don't we take, it is 11:16 now. Why don't we take about a 15 to 20-minute break and be back here at 11:35? Okay?
Yes, Your Honor.
Yes, Your Honor. Thank you.
And with that, we will recess and go off the record. Okay, it is now 11:35. Do I have a court reporter?
Yes, I'm here. Yes.
All right, let's go back on the hearing record. Now, Mr. Felber, can you hear me?
Your Honor.
You had an opportunity to testify. Now it's the opportunity of Ameren, Missouri, followed by staff, followed by myself, or the commission, and as well as any additional recross based upon that. So with that in mind, I'm going to remind you that you are still under oath, and that Ameren, Missouri is going to have an opportunity to ask you questions now. And barring objections to the questions, try and stay on point with answering the question, okay?
All right. Yes, Your Honor.
All right. Ameren, Missouri, go ahead.
Thank you, Your Honor. Inviting your attention to Ameren, Missouri's hearing exhibit 101C. Would you please identify that document?
101C. Let me get to it.
And that is the formal complaint.
The formal complaint. Yes.
Would you please go to the second page and read into the record, paragraph 5.
Which
Uh,
paragraph?
Paragraph 5, please.
Paragraph 5.
Number 5, I believe, is the amount at issue.
Yes. $10,485.
How did you come up with that figure?
Well, number one, how did I came up with that figure based off of what I have actually had. I've actually had to do more than that. I had to, as a result of the actions, I have had to buy a generating system, battery backups to be able to make the house functionable, properable living, since there is no electric to the premises. I'm not going to keep it's not fair to my father. It's not fair to the owner of the premises. So I went out of my way. I purchased the products to be able to make the house functional.
Isn't it true that this figure includes punitive damages?
Oh, it might. It might include a couple of. It does probably have punitive damages, which I was not aware before filing that the commission can instruct punitive damages. However, the actual damages are listed accurately, and that amount, that would be the gas that I've had to supply, the generators that I've had to purchase, the maintenance to the generators, and the battery backups.
Are you waiving your claim for punitive damages at this point?
Inside the commission? Correct, I will. I'll waive the punitive damages part for the commission. Outside of there, no.
Are you also waiving in front of the commission your claim for lost goods?
No.
Where did you?
Would somebody define for me what we're calling lost goods?
That would be refrigerated goods that had to actually be thrown out as a result of the disconnection of things. I probably had about $750 worth of groceries that had to go out because I was not able to get a generator into the property the same day. So I lost spoilage of a lot of stuff. That was between a deep freezer and a refrigerator.
Go on, Ameren, I apologize.
Where did you stay when you incurred the hotel expenses?
Hotel expenses, a Holiday Inn. And then you know what else I also did? Once I got the generator, I went ahead and toughed it out sometimes here. I also travel between businesses. As I've said before, I have places where I can go ahead and whether they're private party, Airbnbs, going from there.
How many days were you at the hotel?
Between hotels, sporadic.
What days were you there?
I would say a total of 75.
Who stayed there with you?
Myself.
Where were your wife and children during this period?
In my house. Or in my parents' house. But they had a generator running. It was supplying. Going from there. My days that I was out, I was attending business meetings in other states and everything.
What was your total bill for the hotel?
After discounts and everything, $4,000.
How much of the $10,485 that you're trying to collect in the alleged damages is for lost income?
That doesn't include lost income. If I had to put lost income into it, I would put Ameren's costing me about $6,000 a month in Avenue channels.
What does that mean, Avenue channels?
And wages where I had to go ahead. I have a dog grooming business that I also run. So I had to find a mobile grooming unit and use that to go ahead and do work. So, yeah.
Now, let me get this straight. You're some kind of cyber computer expert with government contracts and you do dog grooming on the side?
I have a lot of businesses, sir. I also operate a nonprofit church. I've been in the cellular communications industry for 20 years. That was my main deep background. I also, believe it or not, if you want to look up under Secretary of State, I run a nonprofit business that is actually in utility, helping customers that have problems like mine daily. It's consumer regulation. Yes, I
And
have multiple sources of income.
and how many of those businesses did you run from the Florissant property?
Oh, I can run them all mobile. I can run every single one of them. Uh, one of them was the main business would be the dog grooming before the generator.
Are you finished with your answer?
I did finish my answer. The main one was the dog grooming that runs out of here. Everything else I can do remotely. I have sales tax license in Kansas, Vermont, California, Vegas, the whole 9 yards. I travel to the areas. I have a Washington, D.C. address that I've given you before and everything.
No, you didn't give us the Washington DC
Oh, I did.
address. No,
I did.
in fact,
I did.
didn't Judge Clark order you to provide us with a list of every place that you supposedly lived at over the last 6 months, and you refused?
No, actually, I didn't refuse. It's non-irrelevant, sir. What does that have to do with anything? Those are businesses. Those are private. You can look it up public record. Go to the Secretary of State's office of each of those states. There's nothing in there that does that. Nothing. One bit. Whoever, unless you are sort of like the mail, let's go to talk about that. You threw a conniption fit because I have a mailing agent. Does Ameren, Missouri have a mailing agent? Do they have a P.O. box too?
Mr. Felber, it's not your opportunity to ask questions at this point in time.
Okay.
Mr. Felber, isn't it true that after Ameren legally disconnected you, you tried to have service restored in the name of an LLC?
No law against it.
Is that a yes?
It is a yes, and there's no law against it. You show me a law that says it can't be done.
I'll let the law stand for itself. Are you aware that even if you disputed an amount owed to Ameren, Missouri for electric service, you must still pay 1/2 of the amount owed?
That's interesting because you guys never offered that option to the email that I gave you.
Since May 19th, 2023, have you paid Ameren, Missouri any portion of the amount that's owed?
No, because under one of your exhibits, here's the funny thing. When looking at your exhibit list, you guys want $4,000. Actually, let me back up. Let me back up. When the service was actually disconnected, I reached out to Miss Grubbs. I talked to her about setting up a payment agreement plan. Then you entered in, and I told her what was going on. I told her we would apply for, again, medical hardship. We would go ahead and do this. She asked how much I was willing to pay. I told her what we could pay weekly, monthly, whatever. The one thing that you guys stated here on, hold on, it says it right here, somewhere in here. I have to pay, contrary to the amount that the Public Service Commission says of 4,019, in your own exhibit that you sent me, it says I have to pay 4,600.
Mr. Felber, isn't it true that Ms. Kirschmeyer tried to intervene in front of social service agencies to get you some help, and you told the social service agencies, no, that's okay, I filed a complaint before the commission?
She did, what did she do? When did she try to get me social service help?
Before the disconnection. Wouldn't do much good to get it after the disconnection.
She did not try to get me something before the disconnection. If anything was done, was back in March. And then in March, that's the email that Miss Engelbrecht and Miss Grubbs got. So they sent a piece of paper out, and I wanted to proceed with that. And nobody got back to me. And your guys' website is kind of differential of everything because it has multiple things there.
How long have you stayed at the property, the Florissant property that's subject to this dispute?
Say what? Sorry.
How long have you stayed at the property, the Florissant property that is subject to this dispute?
Well, let's see. I was born and raised in this house. So I've actually lived here with my parents. Prior to that, I moved out. I came back in 2011, had a cluster with Ameren on that. And since 2011. And then it had to be put back in my parents' name because you guys tried to say that I used a social security number out of Colorado. When the police ran it and traced it, came back to Missouri. And then services were put back in my name after the bankruptcy filing because I had filed for bankruptcy in 2018.
What's your wife's name?
Lisa Lambert.
How long have you been married to her?
A long time.
So isn't it true that she benefited from the electric service that you received as well as you did?
No, she did not, because for a year and a half to 2 years, she did not. We were on and off in our relationship. She did not benefit before it was disconnected. We have marital issues, such as everybody else does, and that's personal. I don't need to get involved with that. If you want to talk about that on a day, we'll talk about that on a different day, but that's not something I wish to discuss. Everybody has marital issues. Everybody has problems, and going from there. She did not benefit from that, and she's not subject to it. My kids are not subject to it.
Mr. Felber, didn't you call Ameren's city service desk impersonating to be your wife in an attempt to get the service restored?
I did not.
Your Honor, we're going to move that the rest of this hearing be considered in camera. While Mr. Felber has the right, and perhaps has already exercised the right, to waive his privacy issues, we would feel uncomfortable inadvertently interjecting anything that should not come into the public domain. So therefore, we ask that the rest of the cross-examination be considered in camera in its entirety.
I disagree and object.
Well, fine, he can waive his right to privacy, and we'll move on.
No, but here, if you want to talk to my wife, you can ask her about that. I did not impersonate my wife.
I think the question before us at this point is, do we go in camera or not?
I have nothing to hide.
Your Honor, with that in mind.
Hold on, please, Mr. Banks. I understand, Mr. Felber, and I think I've explained to you that under the commission's rules, the commission generally cannot reveal customer-specific information. Customer-specific information is a fairly broad thing, but we've generally used it to include such things as your individual address, personally identifying information outside of your name, which we can't really conduct a hearing without. Social security number has been brought up before, right down even to the specific amounts of some of your bills. As I indicated, all of that is your information, however, and so it is, you can discuss it in testimony, and if you choose to do so, you would be waiving. I don't have a problem going in camera to explain. Mr. Felber, do you know what going in camera means?
Not from your guys' stuff, no.
Okay, why don't I explain it real quick and then we can make a decision there. Right now, there are 21 participants watching this. Many of them have a right to be here, such as the attorneys, myself, commissioners, and even the executive advisors to the commissioners. There may be some, and the court reporter, of course. There may be some people who do not. I don't see anybody directly off, but that does not necessarily mean that that is the case. By going in camera, what essentially I would be doing is doing a breakout room, inviting people to the breakout room that are allowed to hear the confidential information, and then continuing the cross-examination there. I will let you do what you want. I will say that it would be my preference to go in camera because I really don't like putting customer-specific information out there if I don't have to, and I can't see anything that's being served by it. I understand that your desire is to be open and honest. I don't think going in camera has anything to do with that. It just says that maybe this is information that isn't for the larger public consumption.
Okay.
And as I said, the non-in-camera portions of this will be posted to the commission's website eventually for anybody to tune in and see.
Okay.
So what would you like to do?
We'll go in camera. That's fine.
Okay. This is always technically a hard part for me, so I'm going to see how to do this if I remember correctly. So bear with me. Even a I don't believe I enabled a breakout section. Did somebody else? Miss Walters, did you enable the breakout session?
Yes, Judge, I did.
Okay. Do you want to scoot everybody who is allowed to view the information over? That would be all of the attorneys. That would include all of the commission executive advisors, and that would include any commissioners. That would not. I'm going to ask some individual questions. Let's see. All right, I've got all 20 people here, so I'm going to ask some individuals questions. Miss Skurlock, are you allowed to view this information? I'm not getting a specific answer.
Judge,
Yes, Commissioner.
this is Commissioner Coleman. Ms. Sherlock responded via chat to you.
Oh, I see. I am sorry. It says I do not have a mic. Thank you very much for bringing that to my attention, Commissioner Coleman.
You're welcome.
I do not pay much attention to the chat since that is not officially part of the record. But she is.
This is Mr. Keeble. I think, I could be wrong, but I think all staff technically has access to the in-camera confidential testimony and portion of the hearing. Ms. Sherlock would be both an attorney for staff and a member of staff. So I think she is, and I mean, I think all of the staff people qualify, but if you want to do something different, let me know.
No. And I was looking at that and you've answered my question. So here's what we're going to do. We're going to go off the record for 2 seconds. Nobody go anywhere because I just don't want to muddy up the record. And Mr. Lemons, he is our audiovisual person. Is there a reason if everybody is here is entitled to view customer specific information and I am going in camera, is that something where you would prefer that I do a breakout session, or is that something that can be handled post-production before this is posted to the website?
I can do it either way, Judge.
All right. Well, as long as everybody I see here is able to view that information, and I do not see anybody who is not, I am just going. Let's go back on the record.
We're on the record.
Okay. Well, we will go in camera without a breakout session. If more people were to join in the future, necessitating a breakout session for in camera, we would do that. But for right now, we will consider ourselves in camera. And let's go ahead. We are no longer in camera. And Mr. Felber, it is now staff's turn to ask you some questions, and then the commissioners and possibly myself may have some questions for you.
All right.
Go ahead, Mr. Keeble.
Thank you, Judge. Yeah, Mr. Felber, this won't take very long. I don't have many questions for you. Working backward, Mr. Banks was asking you some questions there at the end about another complaint case that you had with Ameren. That's not the only other complaint case you've had with Ameren, is it?
No, I had another, if you want to go back to anything, I actually had a personal case again, or not a personal, a business case last year out of St. Charles County, EC 2023-0103, in which Ameren and the informal side illegally disconnected my business's service for failure to leave a door tag. And then 2 weeks later, they went out and did the same thing. However, it was not Miss Grubbs that entered in the case. It was Miss Chatro. And then Miss Grubbs and I and Miss Engelbrecht, we agreed mutually to restore services, and they also agreed to waive on a deposit amount because I was never informed of a deposit.
Okay. What my point is, you have had previous complaints with Ameren going back some time now. Is that correct?
Yes.
Okay. One other thing I wanted to ask you, so you have some familiarity with the payment agreements, the type of which are at issue in this case, correct?
Correct.
Now, those payment agreements, you have to reach that agreement with Ameren prior to the disconnection. And once you get disconnected, that payment agreement is no longer, what would you call it, an option for resolution, correct?
I wouldn't know. Honestly, I wouldn't know because there's when you call to do a dispute, they don't give you much options. There's no tapes that have been played that said, "Oh, well, this is how you can reach out and do this if you don't agree." All I've said was, anytime that I have filed a complaint, such as the billing, there was nothing given to me. They said, "Oh, well, somebody will reach out to you." Nobody's reached out. Nobody reaches out and asks or does any of that.
Right, but in previous examples, well, like in this case, for example, I shouldn't say in this case, in this instance, you had prior payment agreements with Ameren before the one that may or may not have been reached on May 18th or 22nd, correct? There were payment agreements prior to that.
Correct.
Okay, then how many, do you remember?
Plenty, plus cold weather rule agreements, and yeah.
Right. Now, the cold weather rule agreement is a different type of agreement than what we're dealing with here, correct? Okay.
Correct.
This particular type of agreement, you've had some experience with and aren't those always reached prior to disconnection? I mean, you were never disconnected and then given one of these agreements, were you?
No, I was never disconnected. I do know that if there was something to be disconnected, if they sent something to disconnect, they sent out a letter after those. But I was never disconnected.
And would you agree in the telephone call that Mr. Banks played that he represented was recorded on May 18th? and you said, well, it doesn't say what day it was recorded. Would you agree that during that call, you had not been disconnected at the time of that call?
Correct. I had not been disconnected at the time of that call.
Okay, thank you. Judge, I think that's all the questions I have at this time.
Thank you, Mr. Keeble. Do any commissioners have any questions for Mr. Felber at this point? I hear none. Mr. Felber, I've got a few questions for you. Some of them may seem a little odd or off point, but I'm going to go ahead and ask anyway. I kind of want to start with a kind of a general question, which is, what is it you're asking the commission to do in this case? How do you, if this resolves the way that, if this were to resolve favorably for you, how do you see that being? What do you see the commission ordering?
Here's what, and look, I have not said one bit that I don't owe a bill, but they have not gone, okay, for example, how Ms. Grubbs had said, oh, well, this is this, this is this. Anytime I've asked for something, they've never provided it. In fact, even after discovery, I had sent a letter over to Mr. Banks asking for a ledger copy of everything. I was told by the FTC to send this to them. And even when you act as a private company and you ask, they're supposed to provide ledgers of everything, how they calculated it, going from there. Now, none of that was done. I got exhibits, I guess, that are ledgers of how, whatever, but it really doesn't explain it. My biggest thing of the matter is that I have willed to set up a payment arrangement and a payment agreement. I just want it to be fair. That's all I want out of everything. You know, should it have come this far as what it is? Absolutely not. In any case and instance, for example, in other things, for example, EC 2019, I talked with the counsel for that very nice lady, and I showed her, hey, we had a problem with this. And again, it came to as simple as the what's it called? The deposit on the account. And so she went over and explained it, and then they came back and they actually wound up waiving that portion of it. It's not that Ameren wasn't found of any violation or anything. We agreed to remove it. Same thing on EC 2023-0103. The first time in the informal complaint, Justin and them ordered Ameren because it was a tactic of they used, your threat. This is exactly what happened. You guys have to send this. I feel threatened. That's exactly what they said. And then it came back that they had to reconnect it. And then it went back to 2 weeks later, it was disconnected, and I sent in stuff. And that actually came down to they mailed a disconnect notice later than the time frame of what the 10-day notice was. So then we all kind of gathered together, Miss Grubbs, Miss Engelbrecht, and I, we agreed to go ahead and restore services. I would like a more proactive search. Every representative that you talk to at Ameren, Missouri gives a different statement. Everybody gives a different statement. Everybody says something different. And you don't get the correct story. I have said that numerous times, and each time they've said, well, I'm sorry, this person said, you know, we're going to do customer training on this. We're going to do customer training on this. I shouldn't have to continuously cycle through that. That being said, I'm told to send one thing, and then it's not happy for him. So, oh, no. Let's send this. You send this thing. It shows the same exact as what the first thing says, and you're still not happy with it. Then after that, you know, what exactly is it here? You're asking me for numerous documents, but then when I say, hey, well, show me that document, and you say, well, I don't have that document. Knowing that this was a crucial, knowing it's an illegal disconnection, knowing that this was crucial, I would think you would save each pinpoint piece. Therefore, you can come back and say, oh, well, but this is exactly what you get. For example, in his exhibits,
Well, we're going way off
Okay.
track. I want
So
to get
that-
back to my question. And I understand that you started out wanting to explain something, but we're
Okay.
going well beyond that now. What is it you are wanting the commission to do?
I want them to be able to see that services were disconnected illegally, and I have no problem setting up a new payment arrangement, but services need to be restored with a new payment agreement and date for payment. And that's even what I've offered council to do. I think that's fair. I've offered it 3 or 4 times and there's been nothing. Each time I call customer service, they give a different amount. Like one person said, you have to pay $4,096 to get your services restored. One person says $4,025. And in a response back to the attorney general, it says $4,019. So I could go ahead and pay. So take, while you're wanting a payment towards an account, I can understand that. But when you're giving me an inaccurate amount to pay and it's not going to rectify the situation, what does that do for you? So if I said, hey, I'm going to pay $2,500 on this date to you and yada, yada. Oh, well, that's not going to restore services because you owe 4,000 something. So what is the point? There needs to be a neutralized ground. I'm hoping that the commission can go back and see that and say, you know what? There was a payment agreement. This is this. Let's get these terms knocked out and let's go from there.
Okay, I'm trying to read from, and there's a lot once you get talking. I'm trying to read from that, but essentially what I'm hearing, and correct me on any point I'm wrong, is that you would like the commission to determine that Ameren did in fact commit a violation in disconnecting you. You want the commission to order the reconnection of your services. You want the commission to order Ameren to calculate whatever your correct bill is. And you want the commission to order Ameren to negotiate a new payment agreement with you. Is that correct?
Correct, Your Honor.
Is there anything else?
That's pretty much it. I just want it to be a fair process, and I think that's being fair enough. Nobody should have to suffer for this has gone on since May 19th. Sure, some of my methods unorthodox of what I've sent paperwork in to do this or this or this or this. It is, but it's only human. We're all humans. Imagine yourself being in my position, sending it in, not getting a response. I would think when you see that, and even in the staff report, or in one of the transcripts that was done, which just concerns me, is where council says, well, we're working to rectify situations such as this to put it on a litigational hold. You want to work on what, if you're working on that and you're trying to change everything around, why don't you try to work on the main issue right here that you're seeing live with somebody that's going through that problem before trying to go out and say this? So that way in the future, you can prevent that option, or to me, I think that's a good training method, because you're saying, hey, we need to work on his and why this is this, instead of going off over here. What does that make? It kind of makes it look like you don't want to handle my situation. You want to put mine on the back burner and go from there. I feel that the reason I have no electric right now, and there's been no concern about it, is because I have a generator running the property. There's however many people, Missouri has a lot of disconnections, and I know it's off course of things. There's many people that can't afford to have a generator. What are those people doing? This is about protecting Missourians in the right of things. I would think they would have a heart and be able to look at that and see there is an agreement in place, but it was never approached and acted on properly by the party.
Okay. Now, and you had mentioned staff's report, and I'm looking at staff's report. There was a part that I looked at earlier. It says, on winter calls. He stated he was disputing because according to Mr. Felber, his due date for the down payment and the proposed payment agreement was 4/26 and not 4/24. So there's been an issue you've indicated before with different dates on payment agreements. In a subsequent phone calls, the Ameren representative stated that they researched the issue and found no evidence that the scheduled date was 4/26. The representative, I'll add however here, it doesn't say that, but the representative, however, voided the cutout for non-payment while the issue was investigated. Energy assistant telephone numbers were provided to Mr. Felber, but he declined them. Ameren extended the due date for the payment agreement to April 27th. 4 extensions occurred until Mr. Felber's service was ultimately disconnected on the 19th. So I guess at least one of my concerns is if your service were reconnected and you got everything you asked for, why would we not be here a month from now? Why wouldn't we be starting this whole process over again?
Why wouldn't you start the process over? Because I would live up to the contractual agreement. May was a tough month for me. May was a physically, emotionally tough month. Again, this is where it kind of comes into
And
things.
you've given me enough of an explanation. You don't have to give me more than that.
I want to, as a person, I feel obligated to give you those.
Go right ahead.
My wife has had numerous health issues.
Now, hold on. Before you go on further, I'm going to remind you we are no longer in camera.
That's fine. I'm not gonna say any personal dates or anything. My wife has had to go through 4 surgeries since 2000, right as we had a pandemic, whether we want to call it a pandemic or not, which is physically her ability to do things. I don't like talking about it simply because it's not something I'm proud of. Before the pandemic, everything was going well. Everything, payment history and everything was fine. I don't disagree with that. My wife has had 4 different surgeries, which are complex. My wife's never going to be the same ever again because of how she walks. She had imagine sitting in an operating room and a doctor operating on the wrong part because she was looking at somebody else's medical chart. Looking at somebody else's medical chart, and from there, every day is a crucial pain because she's gone through 2 more surgeries to restructure things. I have my son whose eyesight's been gradually going bad. My wife's eyesight is even bad. However, I am good friends. I'm good. My parents have offered to give me the money to pay the agreement. I have friends and I have business donors that are willing to give me the agreement. I will live up to the agreement because I believe in rectification of being able to do things. I'm a person that I don't like to look back in the past. Nobody likes to look back in the past. We have things that happen. We can't predict each day to the next day. But my personal commitment to everybody is that I will live up to the agreement. We will all live up to the agreement. And all that I want is I should be given that chance based off of the agreement that was never been able to execute. Would I have been able to live up and execute on the agreement? Absolutely. But I had to go and look at the best safety of being able to provide for my family. And that was getting a generator and something in here from there.
And so, and that kind of answers my next question. You opted to get a generator rather than try and pay some of your bill. Is that correct?
Correct, because each time that we had talked to him, there was no reasoning unless services. The only time that I talked to Miss Grubbs, and I offered to pay like $400. I really did. I'm not sure if she remembers that. I had talked to her. I offered to pay $400, and that was during the week of May. When it went to a formal complaint, and then I got my cellular records. I offered to make small payments of like $400 here, there to get caught back up on. I just needed the time. But we also had to have a generator put in. Nobody can live in 100-degree heat without sufficing things. You have to be able to run your air conditioner. You know, we did. We went through stretches of heat. Now we're getting ready to go through stretches of cool, weather where it needs to be functional. It's not like I can go, and the thing is about it is I can't call somebody else and say, hey, Evergy, come in here and help me, or do this. There's things that were done. Am I proud? How everything has transpired? No, I'm not. But I am a human, and I would think you would look at that as frustration is one of those things that it really takes an effect and toll on you. My neighbors have been nothing but great support for me. They've flat out said, being a trooper, being able to try to carry on the function, you got to live a normal life. You got to get up every day and deal with this. All I'm asking is for that chance. And I believe off of everything that's presented, I deserve that chance.
Okay, well, thank you for answering that question. I think I've only got one more, and that is, now you initially filed an informal complaint, correct?
Correct, Your Honor.
And that was after your power was disconnected on the 19th.
Yes, Your Honor.
And then that informal complaint was converted to a formal complaint on the 23rd of May, is that correct?
Yeah, they transferred it to the 23rd.
Okay. Now, and I play devil's advocate quite frequently. Now, you understand that a contract, regardless, if you've got, let's say, just a paper contract, that a paper contract, regardless of what its terms say, is no good until the parties sign it. Would you agree with that?
I would agree.
Now, these payment agreements that are sent out, they're typically not a sign and return thing because they happen primarily digitally, correct?
Correct. Yes. You have the option, from what I gather, they can email you one or they can send one out in physical mail.
I think I believe that there's a requirement that they mail it out, and I believe she asked you if you also wanted it emailed to you. Is that
correct? They never mailed it to me.
okay? Now, a large portion of your dispute here with Ameren is over whether or not a payment agreement was established, with Ameren taking the position that you never made the requisite payment to, they say activate the agreement. I would say kind of the equivalent of signing it. So that's their position. Your position is that once you had agreed to do these things over the phone, the payment agreement was established. Is that a correct understanding of the difference?
It is. And I've even offered for Ameren, and this has been before, when going through situations where we've had misunderstandings, I've asked them, hey, how about we sign something? And for example, in the instance of when EC2, the 1021, where Miss Gibney had gotten everything taken care of, I offered to sign an agreement. However, she said that's something that Ameren does not unfortunately do. Same thing in my complaint that I filed with EC 2023-0103. I offered to sign agreements with them, but Ameren told me they do not sign agreements.
All right, those are all the questions I have for you at this point in time. Are there any questions from the parties based upon bench questions?
Your Honor.
Thank you, Mr. Keeble.
None for me, Your Honor.
Okay, I believe you are done testifying, Mr. Felber.
Yes.
I'm a little concerned at this point. We're at 3:32 right now. I want to see how far we can push today, but I am concerned because it does not appear, at least in my mind, that we are going to be able to finish this before 5 or shortly after. We'll see. I'm going to do everything I can to see how we get down the road. But I'm going to go ahead and inquire at this point before we go on to our next witnesses. What are people's availability for next Tuesday? I say Tuesday because Monday is a state holiday. Mr. Felber, are you available next Tuesday if we have to continue this hearing at some point?
I'm in my busiest times of the year. Hold on one second.
And while he's doing that, I will go ahead. Ameren, what's your availability for Tuesday?
I can move some stuff around and be there, Your Honor. Thank you.
Thank you, Mr. Go ahead, Mr. Feldman.
I can move stuff around to after 12, anytime after 12 o'clock, I would be available.
Okay. Staff, I assume you're available or no?
I could be there, Judge, but I do not know about, yes, I just got a message from my witness. Yes, she would be available as well, so we can make it work.
Okay. Well, we're not there yet. Obviously, I want to get as far as we can today, and if we could finish today, that would be great, but I'm not too excited at this point about running this much past 5 unless we have to. So with that in mind, Mr. Felber, do you want to call your next witness?
On my side or their side?
On your side. They will call their witnesses, you will call your witnesses. Good afternoon, Ms. Lambert. Would you raise your right hand to be sworn?
Yes.
Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
Yes.
Okay. Before we go on, I've got one procedural housekeeping matter I want to take care of. Were you in the room earlier when they were playing the phone call that was allegedly between you and an Ameren, Missouri representative?
I did come in on that, yes.
And was that your voice that I heard on the phone?
Yes.
And did you call Ameren, Missouri on May the 19th? Is that a correct and accurate portrayal of the phone call?
I would assume so, yes. I'm not good with dates, I'm sorry.
Okay. Based upon that, as I previously said, I was waiting to see about getting the necessary element to admit that. Are there any objections at this point to admitting, I've asked this earlier, but I'm going to ask again, are there any objections to admitting Exhibit 104C-F onto the hearing record?
What is
Judge,
that?
Judge, was that Mr. Banks' exhibit?
That
Mr.
was
Felton.
Mr. Banks' exhibit, and I said I would come back to it. Mr. Banks had asked to have it admitted, but because it was a phone call between Miss Lambert and the company, I thought it would be best for her to do the foundational elements.
Okay, may I ask witness a couple of quasi questions?
Go right ahead.
Ms. Lambert, was there anyone else other than you and an Ameren representative on that phone call?
On the phone call, it was just the two of us, yes.
Okay, that's all I have, Judge. I have no objection.
Okay.
Can I explain the conversation on the phone call?
I don't think you need to. We have the conversation and I'm getting ready to admit it on the record so we can actually listen to the conversation. I don't know that there's a need for an explanation.
Okay.
So Exhibit 104C-F is admitted onto the hearing record. And with that, Mr. Felber, you may go ahead and question your witness.
Next question is, at any time prior to the date, did I apply for medical hardship? Did we receive paperwork in the mail in which I emailed Mrs. Engelbrecht prior to the disconnect date of the document?
We did apply, yes.
Who did I talk? Who was my reach out support people to go ahead and talk to at that time?
That I'm not sure. I don't remember who you talked to.
Did I send
No,
you a copy of that email?
Hold on. Mr. Felber, hold on. I have a question. Mr. Felber had indicated that we applied. What part of the application process were you involved with, Ms. Lambert?
I sat down with him to fill out the paperwork. However, he does do a lot of the paperwork for me, just because I am almost legally blind. So a lot of things I can't read, like right now, just looking at the computer screen, I can't read what's on the computer screen on the screen. So he does assist me with a lot of those things.
Okay, thank you. Go on, Mr. Felber.
Is it true Ameren, Missouri did not give a response back to the medical hardship
Yes.
paperwork when we applied?
Yes.
At any time, did you hear any representatives with Ameren, Missouri get combative with me when I would call them and talk about payment agreements, payment arrangements, or wrong dates?
Yes.
Was I ever called a liar on the phone?
I don't think so, but I honestly don't remember.
At any time within the last 2 years, did you live in the address or not in the address? And is it true we have gone through marital problems, and I would just like to keep it at that?
I have lived in and out of the house, just mainly to help my kids have a more comfortable environment. There were times though that I did leave the home and stay with other people and then just come back, just to be around the kids and that.
Is it true Ameren, Missouri was Ameren, Missouri's technician that came out on June 15th combative with me?
Which one? There was two. That was the day that two of them came out, correct?
Correct.
Okay.
I would say it was the one primarily focusing on the technician that was wearing the hard hat and the red.
Yes, because he also did have an issue with me as well. I was at the home at the time when he very first showed up, and he pretty much, I was sitting in the living room, and when he was parked outside of the home, I was sitting there in the window, and he stepped out of the vehicle and he automatically addressed me and told me he was going to come into our yard to disconnect our meter. He needed to make sure everything was off, and I told him everything was off already. There was no reason for him to come into our yard. And that's when he just kind of was like, well, I have to do this. And I'm like, okay, I don't know what to tell him. I didn't want him to come into my yard because, like Brett has discussed before, my dogs are very protective. And if anyone comes into the yard with me or my children here, they do protect us. And so I did not want him coming into the yard when he very first pulled up. And that's why I immediately called Mr. Felber, because I didn't know what to do. I didn't know this man. He didn't come to our door. He didn't knock. He just automatically went to the back and started to get into our yard. Once Mr. Felber got back, I did leave the situation. I'm not comfortable with conflict, so I left so that I was not in the middle of it. So I did not hear their whole entire conversation, but I do know that they were going back and forth. I do know that, but I left.
Was there damage done to the property's premises fence?
There is damage to the fence. It was not there prior. I personally did not see him do it, but it was not there before and it's there now.
Pertaining to a talk that we had with Miss Grubbs the week of May 22nd, did we attempt to make a reasonable effort with Miss Grubbs to work out a payment agreement plan with her with specific amounts in which she brushed off?
I did speak with someone and asked if there was any way. The most of the permanent at the time we could come up with would be $500. I offered to put that down if they would turn on the electricity, and then we could dispute or go through the rest of the amount until we got it figured out and who owed what and what was wrong on the bill and everything, and then we would adjust the rest of the payment after there. And we were refused of that. I did speak to someone that did mention the what are I don't know if it's called a Fresh Start program or whatever they call it. So we did fill out that application as well, and we never heard anything back.
Is it true Ameren, Missouri had St. Louis County Police out here between June 20th and June 21st to have me arrested because I filed a complaint against Miss Terry Engelbrecht?
They came out.
I'm going to rephrase that question. I don't think you can say that Ameren, Missouri sent them out, but were the police out there on that day?
Again, I don't remember the date. They did come out. I did answer the door. They asked to speak with him, and I came out, to wait for him to come out, and I asked what the situation was. And they told me that, they asked if I was his wife, and I said, yes, we are having some issues right now, but yes, I am his wife. And they told me that they wanted to wait to speak to him then. So when they got there, they told us that they had received a phone call from, I believe it was Mr. Banks. I don't remember offhand, but about the situation, the emails that had been received, and they needed to make sure that it was a safe environment and everything. So we went ahead and, sat down and discussed with them exactly what was going on and what had happened. They said they would go back to whoever had contacted them. And after they go back to them, then they would try to get a situation resolved. However, they told him that he probably should stop sending emails because people were not comfortable with their addresses. And I don't know what the email said. I did not type them. So I don't know exactly what was involved, but we did tell them that the emails would stop, and they said they would be back if there were any other issues that needed to be addressed.
At any time did you hear any in phone calls where I've tried to rectify the situation or talk to customer service representatives, did I ever announce and try to use I guess how it comes out, did I ever try to mislead or use any names outside of my business company's names to establish service?
Not during any times that I was here, no.
And then have you ever, I'm not sure if I asked this, have you ever heard in any conversations that I have been involved with you on speakerphone, did you ever hear I was Ameren representatives that were rude, hang up on me, and would call me a liar?
Yes.
And that would be it.
Okay.
Any questions from Ameren, Missouri?
Yes, Your Honor. Ma'am, it's your testimony that you were the only person on that call on May 19th, 2023?
Yes, I was the only person talking on the phone, yes, along with the Ameren employee, of course.
Why did your voice go up about 3 octaves from the time you were talking to the female customer service representative until the time you were speaking with the male supervisor?
The only thing I can tell you is when I get stressed out, my voice changes all the time. If you want doctor records, I have problems with my vocal cords, and it just happens from time to time.
You actually lived at the dividend, you actually lived at the Florissant property on May 19th, 2023.
That is when I was coming back to live here, yes.
Where did you live on May 18th, 2023?
Like I said, I have been bouncing back and forth between family and friends. Occasionally I would stay a night here when we were trying to reconcile any situations we were having. I just kind of stayed with whoever I could in the meantime, just because my kids were here and, you know, I wanted to be here, but at the same time, things just weren't working out. I'm sorry?
Thanks. I'm having difficulty hearing you again.
Did you enter into a lease agreement for the property on May 19th, 2023?
I asked my in-laws for a lease for me to move back in, because he was going to move out so that I could be back here with the kids.
Did you email or fax your lease agreement to Ameren, Missouri on May 19th, 2023?
It was faxed. Brett did fax it for me. Again, like I said, I have trouble seeing all that kind of stuff, so he did do that for me, yes.
You've operated businesses at the property since at least 2022, haven't you?
Have I had businesses here? Yes, we have businesses, yes.
And the property is listed as the principal office and registered office of Dividend Park Property Investors LLC. Isn't that correct?
That is what?
The property is listed as the principal office and the registered office for Dividend Park Property Investors LLC.
I have no idea what my in-laws have it under. I know they have it in a trust, but I don't know the name of the trust.
Aren't you an organizer for Dividend Park Property Investors LLC?
I have started it with Brett. He does handle all of it. My main business that I have is the dog grooming. That's where 100% of my stuff goes to. And then I will help him with other businesses that he has.
And the other organizer for Dividend Park Property Investors LLC is Mr. Brett Felber, isn't it?
He is a portion of it, yes.
Ms. Lambert, your address as listed at the property, at least as of February 27th, 2023, when the articles of organization were filed with the Secretary of State, it lists the Florissant property as the address, right?
I believe so, yes.
I have no further questions, Your Honor.
Thank you, Mr. Banks. Any questions from staff?
Very quickly, Judge, Ms. Lambert, I don't mean to get into anything extremely personal here, so if I apologize, I don't think I'm going to. If I do, let me know. You said that you were off and on staying at the Florissant property after your marital troubles began. Is that correct?
Yes. Occasionally I would stay here.
Okay. And when did you, again, I'm not trying to get personal, when did you initially move out of that property and go to the point where you were just occasionally there?
I have been back and forth. I believe it was 2022. I had 3 surgeries done within 18 months, and it was after those. And my last one was October of 2021. And then it was shortly after that is when I went ahead and started staying with others.
Okay. And I do not mean to make light of your hospitals at all, and I want you to know that I actually also have had 3 surgeries since 2018. So I know what you're going, know what you went through. I sympathize with you on that. I really, truly do. And that's all the questions I have, Judge.
Okay.
Okay. Any commission questions?
No questions, Judge.
Thank you. No questions from the bench as well. Ms. Lambert, you can step down. Thank you for testifying.
Okay, thank you.
Okay. Okay.
It is about 4:15. At this point, I would like to give the court reporter about a 10 to 15-minute break. We seem to be moving a little faster than we would earlier, so I would like to take about a 10, 15-minute break, come back, and I believe, Mr. Banks, you said Ameren, Missouri has one witness?
Yes, Your Honor.
And we will pick up with that witness. So why don't we go off? It's 4:16 now. Let's come back at 4:30. We will go off the record and take a recess until 4:30. Thank you, Mr. Felber. Staff?
Yes, Judge, I'm here. I had to figure out where my cursor was.
Thank you, Mr. Cable. Ameren, Missouri, you may, well, let's go back on the record. And I have a court reporter, correct? Angie, are you on?
I am. I apologize. My internet just restarted and I'm back on. I apologize.
No, you're fine. But you're back on. That's great. All right, let's go back on the record. Ameren, Missouri, you may call your first witness.
I call Ms. Aubrey Kirschmeyer.
Ms. Kirchmer.
Good afternoon.
Good afternoon. Would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this evidentiary hearing is the truth?
I do.
Thank you. Go ahead, Mr. Banks.
By whom are you employed
Ameren, Missouri,
and in what capacity?
as a regulatory liaison.
What is your business address?
101 Madison in Jefferson City, Missouri, 65101.
What is your educational background?
I have a bachelor's degree in business administration from Columbia College.
What is your occupational background, beginning with your tour of duty in the Navy?
Well, I served 4 years in the United States Navy, and upon my honorable discharge, I worked for several years in the corporate filing service industry before coming to work for Ameren, Missouri in 2001. I started my journey with Ameren in the call center. I served as a customer call center representative, and then I transitioned to an administrative assistant role. Prior to leaving customer service, I was a call center supervisor. And then nearly 6 years ago, I transferred out of the call center into my current role within regulatory affairs.
What do your present responsibilities include with Ameren, Missouri?
Well, in regulatory affairs, I support our team by assisting with the investigation of all third-party complaints against Ameren, Missouri. I primarily am independently responsible for handling executive complaints and formal complaints in front of the commission. I serve as company witness. Another important role that I serve in my current duties is I do a deep dive review of all of our complaints received. And what I'm looking for is not only regulatory compliance, but I'm also looking for continuous improvement opportunities that we might put into place within our business operations to make a better customer experience for our customers. And I also provide regulatory guidance to our coworkers to ensure that all of our business operations are within regulatory compliance.
For lack of a better word, were you the company's liaison when it came to this investigation?
Yes.
And were you responsible for assembling documents?
Yes.
were you responsible for responding to data requests?
Yes,
The documents that you provided, were they kept in the regular course of business for Ameren, Missouri?
yes,
Were they compiled roughly at the same time expressed in the documents? In other words, were they contemporaneously prepared?
yes,
For purposes of today's proceedings, are you considered the custodian of records for Ameren?
yes.
When did you first become familiar with complainant?
I first became familiar with the complainant during the investigation of a formal complaint filed in late 2018, which I investigated and worked through.
Invite your attention to page 2 of complainant's formal complaint, Exhibit 101C, line 5, where it asks the amount at issue. $10,485. Is this figure correct?
No,
Invite your attention to page 2 of complainant's formal complaint, line 6, where it says, complainant now requests the following relief. Complainant says, Ameren, Missouri fraudulently and purposely disconnected service at the property, which I'll hereafter refer to as either the property or the location. Is that correct?
no,
Did you thoroughly investigate this complaint?
yes, I did.
Why did Ameren, Missouri disconnect service at the property in May of 2023?
For non-payment of an undisputed delinquent charge.
Mr. Felber continues to allege in his formal complaint, Exhibit 101C, that Ameren, Missouri used spoofing methods to pretend it was the Boone County government. Is this true?
No,
He goes on to say that Ameren, Missouri incorrectly billed him the wrong amount. Is this true?
no,
Invite your attention to section 7 on page 2 of the formal complaint. It says Ameren failed to follow proper protocol when attempting to disconnect service. Is this true?
no, it is not.
He goes on to say, Ameren failed to allow me to dispute the abnormal high balance I didn't owe. Is this true?
No,
Invite your attention to page 3 of the formal complaint in section 8. He says, I have reached out to Ameren on numerous occasions only to be hung up on, called a liar, and yelled at by numerous agents. Are all of Ameren's customer service calls recorded?
yes. All of the calls between our customer care advisors and leaders with customers are recorded.
Are the recordings for the customer service calls saved on the Ameren, Missouri system in the regular course of business?
Yes, they are. We use a application called IC Business Manager to record all calls with our customers.
Did the staff ask for all of these recordings in the form of a data request?
Yes,
I'll invite your attention to exhibit, Your Honor, at this time, I move that exhibit 101C be accepted into the record as evidence.
Any objections to admitting Exhibit 101C onto the hearing record? That is Mr. Felber's formal complaint in this case. Hearing no objections, Exhibit 101C is admitted onto the hearing record.
The response to staff data request 2, which is exhibit 104C, was that prepared by you?
yes.
How did you compile all the calls provided in response to staff data request 2?
Well, as I mentioned, we use an application called IC Business Manager, which I informally refer to as ICBM. So when I was searching for all of the recorded phone calls between Brett Felber and on behalf of the account at the property address, there are several different ways to search in ICBM for recorded calls. And so I utilized all search available functionality. I first searched by the account number. So all calls that have been authenticated through our IVR, our interactive voice response unit with that account number, then show up. So I pulled all of those calls. I also pulled all calls that came in or went out to the telephone number on record for Mr. Felber's account. And as a fail-safe to make sure that I wasn't missing anything, I then cross-referenced all of the account contact log interactions that had been entered within our customer billing system, which is called CSS, Customer Service System. So I went through the CSS account contacts that were left by our call center advisors and leaders and other employees, and went through every contact line by line to make sure that I hadn't missed any calls. There were a few calls that likely hadn't been authenticated through the IVR, so there were some calls that I were able to pull that way. And I pulled the calls that way by searching by the employee's name and the date and the time, and was able to pull those additional calls. So I feel confident that by utilizing all available methods of pulling calls, that I did capture all of those.
About how many formal complaints have you worked on in the last 5 years, approximately?
Perhaps 20? That would be a rough estimate.
Were you surprised when the staff provided a data request asking for all those calls?
No, that's very typical on a formal complaint that staff will request a listing and recordings of all calls. So that's very common.
Did you listen to all of these recordings before you gave them to staff in response to staff data request 2?
Yes, I did.
The recorded phone calls listed have a series of numbers associated with them. How do these numbers correspond to the date of the call?
So every recorded call has what we refer to as an interaction ID number associated with it. It's basically a long string of numbers. The first 6 to 8 numbers are randomly collected. The last 6 digits of every interaction ID is the date that the call was recorded. And now, when I go to save calls, it defaults to saving that WAV file with the interaction ID number. However, from my experience, especially in a situation where there were well over 100 calls, it's very difficult to be able to pinpoint which call went with what date just by saving with the interaction ID number, since it is such a long number. And not to mention, there were many dates, especially in this particular case, where there were 6, 7, 8 phone calls on one particular date. So if I were to save the calls with the interaction ID number, there would be no way to differentiate this was the first call on that date, this was the second call on that date. So when I save the calls in order to submit those for the data request response, I renamed each file with the date of the call, and that does correspond with the date, the last 6 digits that are on the interaction ID.
As the company representative, were you present throughout this hearing today?
Yes, I have been.
Did you hear Mr. Felber question whether or not the May 18th phone call actually took place on May 18th, 2023?
Yes, I did.
Is there any way that you can look at the file name and tell that it was generated on May 18th, 2023?
Well, yes, as I mentioned, I saved the WAV file with the date. And so there was, I'm looking through my data response request to data request 2, and If I go to the third page, it looks like there was only one call on May 18th, which I uploaded, or we uploaded as a response. So the call that says 051823 was the call that we listened to today that was made, Mr. Felber and one of our advisors. That was their interaction that was recorded on May 18th.
Your Honor, I move that Ameren, Missouri Exhibit 104CA be accepted into the record.
I heard you. Bear with me just a moment.
Yes, Your Honor.
Mr. Felber, have you had an opportunity to look at 104CA? It is response to staff data request MPSC 0002. And in terms of where it is, it looks like it's a little past halfway through. It is after the account notes and field notes and contact logs. And I don't know, you're muted.
Is it in the call logs or where? Is it?
I assume when you say call logs, you're looking at the field notes and context log. Just past that, there is, if you look at the bottom, there's an exhibit. The last page of that is the last page of exhibit 103C. And then the following one, which is not labeled anywhere that I see 104, is the MPSC data request 0002. It looks substantially similar to the previous data request as to the top part. And the bottom part, it lists a series of numbers, and you'll see like first call, second call, first call, second call, third call, etc.
Hold on.
It seems to be a list of file numbers.
File number. Okay, I think I was at it and then I got out of it. Hold on. It's sorry, there's a long list of this is
It appears to be calls from June 2018 to June 3rd of this year.
Is it okay? It's not this thing. It's number MPSC 003.
0002.
002. This right here.
0002. I can't see what you're looking at, Mr.
Okay.
Felber.
Response. Yeah.
Okay. Do you have any objections to admitting that the response to that data request onto the hearing record?
I mean, I guess my question is this an actual data log or what is it? I mean, all this is typed up piece. All this is typed up words. How do we know that's an accurate log? I mean, there's no transcript between anything that shows a caller, a sender, anything of that nature. So it could be multiplied and produced. I mean, this doesn't do anything. What does, I guess my question is 112019, 120219. All this is just
words that are typed. It doesn't actually go into a broad definition of things that states, hey, this is this. I would think if you're making crucial, log data of things of what you've done in this, I mean, I would think there would be a more elaborate thing instead of first call, second call, follow-up change. And, it's really blank. There's nothing really behind it. It doesn't show anything. It doesn't show what day the phone call is made. It doesn't show that this was made. Anybody can sit there and type on a piece of paper and say, oh, well, I made this WAV file for this day.
If you go to page 3 of 4, and I go about halfway down, it says 051923, 7th call from Lisa Lambert requesting service. That 05 would be May, 19 would be the 19th of May, 23 would be 23. I believe that was what Ms. Kirchmeier just explained. So this appears to be a list of calls she compiled for the staff of the commission. Is that correct, Ms. Kirchmeier?
Yes, Your Honor.
Were all these calls submitted to the staff?
Yes, sir.
And all of these calls were recorded?
Yes.
Okay, so yes, it is a list she provided, but it is a list that she had made of calls that she provided to the staff of the commission. So do you have an objection beyond what you voiced?
I do, because like, for example, we don't have, okay, I understand. Call from Lisa Lambert requesting service. No CSS contact. We can leave these things blunt. Okay, so you're going to put that down there. Like, okay, for example, Scrappy Lacholo. We're going to put that on there, but then everything else, and this is even going back to page 104. We're not really, there's nothing labeled. So we're only labeling selective phone calls here. We're not actually, is there, I would honestly want to know, and you guys use message broadcast, right?
Don't answer that.
Is that correct? You guys use message broadcast for your provider?
You'll have a chance to ask that during cross-examination.
All right. Okay.
Let me follow up with that. Are the calls that are not labeled as to a particular person who's not Mr. Felber, would all those be calls from Mr. Felber? Is that why those are unlabeled?
Yes, Judge. The request was asking for recorded calls between Brett Felber, and in parentheses also include calls with anyone else that contacted the company. So all calls, if they do not indicate anything other than, if they don't have a name listed, those were calls that were Brett Felber.
Do you have any further objections to this document, Mr. Felber?
I mean, they can admit it. I just don't see the relevance of it. I think it's kind of, it's one of those things that's typed up. It's not, if it was something that was given to, honestly, from a provider, that would actually shed more light. And I know message broadcast does give out a call log.
And I agree with that. That would probably go more to the weight of the exhibit rather than the admissibility. So I'm going to overrule your objection, and I'm going to admit Exhibit 104C, confidential Exhibit 104A onto the hearing record. So that is admitted.
Ma'am, did you, as part of your practice in responding to staff DRs in a complaint investigation, listen to and compile the recordings of calls?
Yes.
Is there one instance, just one instance, where a complainant was ever called a liar?
No.
Was there one instance where he was hung up on?
There were several instances where the call center representative did disconnect the call after following the appropriate policy, call center policy of advising Mr. Felber that there was nothing else that they could assist with, that the call wasn't really being productive any longer before disconnecting the call.
Was there one instance where Mr. Felber was yelled at?
No.
In the formal complaint, Exhibit 101C, complainant goes on to say that he has filed a civil suit against Ameren, cause number 2022-SC-002047. Now, Mr. Felber has filed a nuisance lawsuit against Ameren, Missouri, its outside counsel, and employees in Texas. To your knowledge, at the time he filed his formal complaint, had any such lawsuit been filed with the above styled cause number 2022-SC-002047?
Not to my knowledge, no.
Finally, the complainant concludes, I believe Ameren is going to continue these same fraudulent activities until they are sanctioned and punished by courts and the PSC. Is this true?
No.
Invite your attention to data request number 1, received from staff, which is exhibit number 102C. Were you asked to provide all account notes, bill notes, and contact logs for the account at the property from June 2018 to date?
Yes, I was.
Did you respond to this data request?
Yes.
Did you respond by providing 83, that's 83 pages of account notes, field notes, and contact notes for the property in question?
Yes.
Where did you obtain the list of account contacts listed in the data request?
These were compiled and pulled directly from the main billing system that we use, which is called CSS, and that refers to customer service system.
Are all account contacts made and saved in the course of the regularly conducted business activity of call center and customer service operations at Ameren?
Yes.
Are account contacts routinely made in the course of business by Ameren?
Yes.
Are account contacts entered into CSS at or near the time of the event of the contact?
Yes.
Who enters the account contact?
The Ameren employee enters the contact directly. For the most part, it's our call center personnel, but there are others outside of the call center that also enter contacts when they have been working with a specific account. There are also quite a few contacts that are auto-generated, and those contacts are entered automatically by the system. For example, a non-pay disconnection notice mailed or something to that effect.
So account contact is either automated or noted by a person with knowledge to note such contact.
Yes.
In response to data requests or questions from the staff in the complaint case, does Ameren, Missouri regularly present such records/account contacts?
Yes.
Direct your attention to exhibit 106C. In response to staff data request number 4, did you provide the commission staff with the complete payment history for the location from June 2018 to June 2023?
Yes.
Where did you obtain the payment history provided in response to data request number 4, exhibit 106C?
That was obtained from CSS, our billing system.
Are payment history saved in the course of the regularly conducted business activity or operations of Ameren?
Yes.
Are payment histories routinely tracked in the course of business by Ameren?
Yes.
Are payments and billed amounts shown in the payment history recorded into Ameren, Missouri's billing systems at or near the time of the event recorded?
Yes.
in response to data requests or questions from staff in complaint cases, does Ameren, Missouri regularly present such records or account contacts?
Yes.
When was the last time, let me back up and move, Your Honor, that Exhibit 106C be accepted into the record?
Well, were you going to do anything with 102C, or was that just for?
I would move to 102C as well, Your Honor. Thank you.
Mr. Felber, have you had an opportunity to look at Exhibit 102C?
I've looked at all the exhibits, and honestly, to tell you the truth, this is the most confusing thing that I've ever seen. I mean, cutting right to the point of everything, are we here to put how you personally feel about it, or is there something that you can provide that shows what was actually done? I mean, everything here is typed up stuff how things works. None of this is. I mean, I think we wasted 15 minutes of her. While I appreciate her time in the service, that was irrelevant to the whole thing. We're not after her credentials outside of Ameren, Missouri. We're after the public interest of the matter. I mean, if you wanted a biography of her record for 15 minutes, I could go on for 40 minutes about my credentials and who all I know and who everything is. But I mean, I've honestly lost track of this. Because everything.
Well, I will agree that her career in the Navy is not necessarily germane to this particular complaint. It is not unusual, when people are questioning witnesses to go over their general background, as it might be of interest. What I'm more interested in is Exhibit 102C at this point. The way Ms. Kirchner explained it is, yes, this is all stuff that's typed. Everything is typed by somebody. My understanding is that whatever employee was interacting with the account at that time was making these notes. Is that correct, Ms. Kirchner?
Yes, it is.
And these are the actual notes as they would have put them in. You didn't type this up.
I did not. We are able to pull a record and it pulls it into a Word document, quite honestly, and it captures all of the contacts from the dates that you're requesting. So it's an automatic process that pulls these directly from CSS.
So if I'm looking at something and it says the date 2021-07-15, 6:27 p.m., I assume that's when it comes. It comes delinquent inquiry, request setting up, PAG, which I'm assuming is payment agreement, the agreement, and then it gives, that's kind of whatever call center employee at that time was interacting in regard to that account, that's their notes.
That is correct. And as I mentioned, there are many automated contacts, and you'll see those as well. The date timestamp is the time that contact is entered into the system. And then there are many that say batch process. And those, what I mentioned, are the automated contacts that are automatically added to the billing system when that action occurs. So when we pull contacts, it's pulling all of the account contacts, those that were entered manually by advisors at the time of the call. Those are their notes from the interaction they had with the customer, and all of the batch process contacts, which are automatically added once whatever the action was that occurred, such as an automated collection call. Or
so when I'm looking at something that says correspondence collections, pink disconnect notice due, issued by batch process. That's what you're talking about.
That is correct.
That's where the computer kicks out a notice.
Yes, Judge.
Okay. Beyond your objection that it's just stuff that typed up, do you have any other objections to this exhibit 102C?
I mean, this is just, I don't see what purpose it really serves. I mean, to me, I think this is I mean, when you have over 40 pages of this, none of this describes the action of when I call to sit there and say, okay, well, let's
Are we after what every word is said, or are we after the main argument of a payment agreement?
Well, as again, that's the tree you're interested in. They're interested in a different tree.
I mean, this is to me, it's a sidestep away from okay. To me, it's a sidestep away from the fact of. I mean, I understand you want to have a call log of everything and all that, but a lot of this is just irrelevant.
Ameren, why is this important to you? What's the purpose of this exhibit?
Because the staff asked for all this information, Your Honor.
But why are you wanting it admitted onto the record?
Because it shows that we're compliant and it shows the complete history of the contacts that were made.
So this is actually from your vendor. So if I called your vendor and I had the chance to inspect it from your vendor, which I'm very
Chris,
good.
I understand what you want to ask him, but why don't you make the point to me?
Okay.
Things
Sorry.
go awry when the parties are talking to each other.
Sorry.
That's what I'm in the room for. Talk to me.
I
Well,
know this vendor right here, and I know for a fact that they actually give an itemized list. So if I was to call and have a contact with their corporate field specialist, he's not going to give me anything different. He's not going to tell me that they actually have different stamps that are put on it. They actually have a data trace that's put on it. They have a record key code that's put on it. I sell their services for a living. I'm very quite frank with them.
I'm going to overrule your objections. I'm going to allow it on for the purposes of showing that these were all the company contacts in relation to your account between the time periods listed.
That's fine.
So exhibit 1, is it 103C or 102C?
102C, Your Honor.
Thank you. Exhibit 102C will be admitted onto the hearing record.
And Your Honor, did you rule on exhibit 106C?
I had not gotten that to that yet, so why don't we go to that right now? 106C is another data response. It's 0004. Have you had an opportunity to look at that, Mr. Felber? Front of it says page left blank, at least when I print it off, because it says page left blank intentionally.
Okay. So it goes down to,
Well,
I
no,
guess.
that's the end of 105C. The beginning of 106C is another data request. It looks the same. It says MPSC 0004 at the top. And at the bottom, it does say Brett Felber, B. Union Electric, doing business at Ameren, Missouri, confidential hearing exhibit 106C.
All right.
And
Yeah.
it just appears to be a grid of payments and returned checks. And with that, I actually had a question in regard to that. With those, is that just returned checks, or is that returned or like failures of cards to process?
It could actually be both, Judge. The payment could be returned whether it was a credit card payment or an actual check payment.
So when it says check returned, it just means payment returned.
Correct.
Okay, thank you for clarifying that.
I would strongly disagree with that. If you have I would disagree.
Disagree with what?
Well, usually what happens if you have a declined card, it would give you a batch number still and the declinal number, and it would show that in trace. Same thing with if there was a check, it would show a trace of that. There's always a tracer for it.
Mhm.
It's always been utilized in any banking industry. I take credit cards right now. I could physically walk over to a machine and I could decline it, and I could give you a transaction batch ID and everything.
Okay. Do you believe that the amounts that you have paid from, it looks like July 24th, 2018 to November 2nd of 2022, do you believe that incorrectly represents payments you've made?
That is correct, because I know that I have made payments that have cleared their bank account that I'll probably have to go back and now siphon over.
I'm not sure I understand what you mean there.
I know not all my payments were returned. I do know
It
when I
doesn't
put
say
it.
that all your payments returned. It appears that only 4 payments were rejected?
I know one, and this was actually part of a dispute, and I believe it was one for, if I'm believing right, it was 6/17/2022 at 138. That was approved by Square. That was approved off my debit card from Square, and I actually had to call you guys and actually set up an open investigation to that, because then you told me that Square had to give a bank letterhead. So Square actually reimbursed me those funds because you guys did not respond back to the agreement. You guys also didn't respond back in 2008 to a payment that you guys misapplied to my account that Bank of America had to credit, because you guys never responded. Your Treasury Department?
Okay, why don't you give me a clearer explanation? Does this, you said you made a Squarespace payment?
No. Off my debit. Okay, so Square utilizes a bank as well too, personal or business, and I used it for personal and business. And I made a payment for $138, and I called their department, their customer service department told me that Treasury was going to get in contact with me, and I had to have a bank letterhead come out. I got a piece of paper that was back in 2022. If I dug it out, probably I could submit it if I needed to. They initiated a complaint with Square, or with their Treasury Department at Ameren, Missouri, which is a different address than 1901 Chateau. And you guys failed to respond to it, which resulted in a provisional credit to my account.
Okay, what was this, what date was this payment made?
6/17/2022.
It's for $138?
Correct.
Okay, well, it appears on there. It appeared it was returned, whether it was correct or not, whether you ultimately were successful in that. It appears that that was at least recorded on there. If you go down to 6/17/2022, it says 138.
Yeah, but I think they say it was returned. So either
They say it was returned, and you're indicating that it wasn't, or that it was ultimately resolved and you were refunded, correct?
Correct. I was refunded by Square. Or blocking is who the financial institution is.
Okay. Well, taking your objection into account, I'm going to overrule it and admit it for the purpose of showing the payments that were made between, where is it? June 2018 to the date that this data request was logged, which is 6/16/23. So Exhibit 106C is admitted onto the hearing record. Go ahead.
Where did you obtain the payment history provided in response to data request number 4?
From our billing system, CSS.
Are payment history saved in the course of the regularly conducted business activities of operations of Ameren?
Yes.
Are payment histories routinely tracked in the course of business for Ameren?
Yes.
Are payments and bill amounts shown in the payment histories recorded into Ameren, Missouri's billing system at or near the time of the event determined?
Yes.
In response to data requests or questions from staff in complaint cases, does Ameren, Missouri regularly present such records?
Yes.
When was the last time that a payment was made on the account that was not returned for insufficient funds?
February 16th of 2022.
Inviting your attention to staff's data request number 5, Exhibit 107C. If you provide staff the list of payment plans entered into by complainant,
Yes.
Where did you obtain the list of payment plans set out in Exhibit 107C?
From our customer service system, CSS.
Are logs of payment plans saved in the course of the regularly conducted business activities at Ameren?
Yes.
Are payment plans routinely tracked in the course of business for Ameren?
Yes.
Are payment plans recorded into Ameren, Missouri's billing system at or near the time of the event recorded?
Yes.
In response to data requests or questions from the staff in complaint cases, does Ameren, Missouri regularly present such payment plan details?
Yes, we do.
Your Honor, I move that Ameren, Missouri Exhibit 107C be accepted into the record as evidence.
What's the purpose of 107C? And the reason I ask is because it appears that the last payment agreement, or if I'm reading this wrong, was this on September 28th of 2022. How does that relate to this complaint? I guess is the question.
The data request was quite comprehensive, Your Honor, and we responded as comprehensively as we could. It does show the pattern that was in existence and the various payment plans that the complainant had.
So you were offering this to show the various payment plans that he's had since June 18 to date?
Yes, Your Honor.
I have a question regarding that. Why doesn't the May 18 payment plan appear on that?
Judge, if I may, I did make a note at the beginning, right underneath the confidential heading, that only information on payment agreements that were actually established has been provided. Pending payment agreements that were not actually established due to the required down payment not being received have not been included. Since that May 18th payment agreement was not activated, there was not a payment agreement established or set up. So that's why it's not included, Judge.
Okay. And I know that Ameren and Mr. Felber disagree on that point. As I indicated before during this hearing, my understanding from staff's report is there were 4 payment agreements that were extended. Is that correct?
Well, there were payment date extensions, perhaps. We were, Mr. Felber's account was granted extensions, but they weren't necessarily payment agreements set up.
In other words, there had been no initial payment made,
Correct.
but the date for him to make that initial payment was extended several times?
Correct.
So the only purpose this is being offered for is to show that Mr. Felber had payment agreements in the past.
Yes, Your Honor.
Okay. Well, as to that purpose, Mr. Felber, do you have any objection to admitting Exhibit 107C onto the hearing record for that limited purpose?
I'm not sure why they would want it admitted. I would think you would list every payment agreement, and this just helps me out more because it shows that they're trying to hide May 18th for May 22nd. That's the only thing. You know, what's kind of funny about this is, and I want to bring a point to it.
Well, I understand you want to talk about it, and you'll have an opportunity. You can certainly question Ms. Kirchmeier about it.
Okay.
But it doesn't sound like you have an objection to it at this point.
No, because
did you believe it's helpful to you? Are you objecting to it being admitted, or are you?
Add it in.
Okay, Exhibit 107C is admitted onto the hearing record.
Where did you obtain the list of payment plans set out in 107C?
From our billing system, CSS.
Are logs of payment plans saved in the course of regularly conducted business and activities at Ameren?
Yes.
Are payment plans routinely tracked in the course of business for Ameren?
Yes.
are payment plans recorded into Ameren, Missouri's billing system at or near the time of the plans being entered into or defaulting?
Yes.
In response to data requests or questions from staff in complaint cases, does Ameren, Missouri regularly present such payment details?
Yes.
Did Ameren enter into multiple payment plans with complainant?
Yes.
The complainant generally follow the agreed upon terms and conditions of these payment plans.
No, all payment agreements that we established with Mr. Felber defaulted due to missed payments.
Did the complainant's refusal to follow the agreed upon terms and conditions of his most recent payment plan result in the disconnection of the service at the property?
Indirectly, yes. His last payment agreement, as the judge mentioned, from this data request response was in September of 2022 that we established it. He did make, that payment agreement defaulted in December of last year, which, once a payment agreement defaults, the entire balance that has been deferred immediately becomes due on the account. So that led to the very large arrearage on the account. So it was actually that large arrearage which led to the disconnection of Mr. Felber's service on May 19th.
Your Honor, I'd like to ask you a question.
You'll get an opportunity to, but not right now.
Ma'am, are you familiar with the complainant's exhibits 8 through 11 in this matter?
You'll have to refresh me, please.
I believe that exhibit 8 is the purported payment agreement. Exhibit 9 is a payment agreement watermark. Exhibit 10 is the information provided by SendGrid Trilio. And exhibit 11 is the payment agreement Trilio received.
Yes, thank you. I am familiar with those.
One moment, please, Your Honor.
Ms. Kirchmeyer, well, I'm not gonna want Mr. Banks to be able to hear.
Okay.
Does the company believe these filings to be accurate?
No.
Hearsay.
It's not hearsay. He's asking whether her, as the representative of the company, believes your exhibits to be accurate. It's just a question as to what she believes.
It's not something factual to the ground of the point, and it doesn't go off the base. Anybody can say that. I can sit here and look at their stuff and I can say it's fake.
I assume so, but I assume that we're going to hear why. So I'm going to overrule your objection and allow her to answer.
Okay.
Ms. Kirchmeyer, why?
I have clear evidence that the down payment required for the payment agreement that was discussed on the May 18th call, that down payment was required to be paid on May 18th. Without a shadow of a doubt, that was the down payment required date. So the documents that I see that Mr. Felber submitted that give a required payment due date of May 22nd are altered. We have, although we were not able to obtain a copy of the specific email because Mr. Felber it didn't come up until more than 30 days after that email was sent out on May 18th. We have plenty of data, including the values that we sent to our message broadcast vendor, which clearly state that the required due date was May 18th. We have the telephone call that states the date that the payment was needed that day, May 18th. So I have no doubt in my mind that this email that indicates that there was a required payment due date of May 22nd was altered.
Let's look at your response to staff data request number 27,
Mr.
exhibit
Banks,
19.
Mr. Banks, can I ask a quick question about 107C, just to
Sure.
clarify? I don't understand why the 9/28/22 deferred payment agreement, you said these were payment agreements that in your words were established, correct?
Yes.
Why does that payment agreement have a down payment amount of 0?
Well, there are times that we offer a payment agreement to a customer without requiring a down payment. So at that
Why?
point, well, let me, if you don't mind, I'll look at the contacts, the account contacts from that date, and I can tell you.
Please. And I'm sorry to interrupt you, Mr. Banks. I just,
Oh, that's okay, Your Honor.
2022. I'm normally quicker than this, Judge. I apologize because normally I'm on my computer, but I am looking at the printout, so it's just taking me a moment.
I understand.
Okay. So on September 28th, we actually had, it looks like Mr. Felber had reached out to our legal department and there was some type, I see. Okay, so on September 26th, we actually received an intent to sue letter directly from Mr. Felber. He sent that directly to our legal department and our regulatory department. So he sent us an intent to sue letter along with a copy of an envelope mailed on September 21st. So we were concerned. We wanted to make sure that, Mr. Felber was, disputing his balance. There was a concern there. So at that time, we made the decision to offer him a special payment agreement. He had agreed that he would, if we were able to work with him, that he would set up another special agreement. So we did agree with Mr. Felber that we would set up a special payment agreement with no payment down. And we took his entire balance at that time and split it into monthly installments since we were working with him to try to resolve his concern at that time.
And that's also the reason that was 24
Correct. Instead
of what you would usually see, which would be 12.
Correct. So we do obviously have, the ability to make judgment calls in certain situations and go outside of what our normal boundaries are if we are really trying hard to work with a customer. And that's what happened at that point. So we did agree to this special arrangement. We broke his balance into 24 months to hopefully make it easier for him to keep the terms of that arrangement. So that was a very good question, and that's exactly why there was not a down payment required.
Okay, thank you for that, and I'm sorry for breaking up your flow, Mr. Banks.
No, that's okay, Your Honor. And let's see. Was number, Ameren, Missouri Exhibit 119C, was that accepted to the record?
Not yet. We had not gotten there yet.
Okay.
But I will say we're bumping up against 5:30, and as much as I hate to split a witness, I think we ought to address. I do not see at this point with you still have a number of exhibits to enter. Mr. Felber still gets to cross-examine, as does staff. Commission questions from the commissioners or myself. And we additionally have a staff witness to go through. So I'm thinking this is maybe a good time to break, unless there are objections.
I'm
Judge, I was going to ask you about that myself because in a half hour I get locked out of my parking garage. It's effectively locked out because of my problem with my legs. It's hard to be. They lock the elevator at 6, so after 6 I can't use the elevator in the parking garage. So if since we're unlikely to get to go home to get finished with this hearing today, I would like to get out of here as soon as possible. Just throwing that out there.
Ameren, Missouri?
No objection, Your Honor.
I appreciate that, and I apologize that that we can't run late into the evening. I'm frankly just running out of steam, and it is getting late. Commissioner Kolkmeyer, Commissioner Holzman, do you have any objections to me doing that?
No objections, Judge. Thank you.
Thank you, Commissioner.
No objection, Judge.
Thank you very much, Commissioner Holzman. I believe, Mr. Felber, you said you were available Tuesday afternoon. Is that correct?
I'm going to change my schedule to be where I'm available before that time at 9 a.m.
And I may have to step away here for 2 seconds to check my wall calendar.
There is one thing I do want to bring up.
Okay, go ahead.
Earlier, Mr. Banks, you made a comment to my daughter and asked if she loves me. I understand your counsel, your job. Please never, ever, ever bring that ever up again. My family loves me. I love my family. For you to do that is unethical. For you to even ask that question.
I think you misunderstood that question from the way I understood it. I can see how you took it. The way I took it was, of course you love your father. I think where he was going with that ultimately did not get there. But that's not how I took the question. I did not take the question that he was actually questioning whether or not she loved you. That's now how I took it. I took it as, of course you love your father. And essentially, you know,
and this
you
is another,
love your father enough to testify on his behalf. So that's how I took it.
and I'll agree to recess. However, again, this is another weekend that they get to go ahead and have their opinions. And I understand it's an evidentiary hearing, but they're not providing anything conclusively surrounding a payment arrangement or payment agreement. They're stating what they want to do. They spent 15 minutes alone trying to, oh, what's your credentials? This. Nowhere in her credentials did she put she's a software engineer. In fact, I mean, if we could have taken 15 more minutes out of that time of her.
We're not finished with her by a long shot. You are certainly welcome when you get an opportunity to question her, to ask her what her software experience is. You are certainly welcome during that time to ask the question I did not let you ask at the time, which is, you know, who their vendor is and who their provider is, I believe, as you said. You will have an opportunity to ask all those questions.
I have
as
a
you
question.
As you heard me say at the beginning, I am trying to hurry this because I am of the opinion that justice delayed in this case is justice denied, because win, lose, or draw, you need to be able to move on with your life with a plan moving forward. So in any event, you need an answer. It's one of the reasons, normally in any case, I would order briefs unless it were an extremely simple case, which yours is not. And I'm not ordering briefs, but doing closing arguments. So I'm doing everything possible to get your hearing done as speedily as possible and to get a commission order out as quickly as possible, and yet maintain quality and respect for everybody's due process involved, including yours and including Ameren's. When I indicated that one of my jobs is to ensure a fair trial for you, it is also to ensure a fair trial or hearing for Ameren and a fair hearing for staff. So you'll have an opportunity. I'm sure Ameren would probably like to go on, because you will have an opportunity over the weekend to formulate some of your questions. So let me get back to checking my calendar. As I indicated, Monday is a state holiday, so I did not mean to. I'm gonna go check my calendar, please. Wait just a sec.
Oh yeah, I gotta get ready for SmackDown.
Are there any objections to starting at 9 a.m. on Tuesday, the 10th?
No, Your Honor.
No, Your Honor.
Cameron? Staff?
Not for me, Judge. I just sent a chat message question to my witness. See if she can get back to me quickly on that. If not, we'll assume she's available if we don't hear from her quickly here.
Okay, and Angie, are you or somebody from your agency available as a court reporter?
I'm sure they are. And I apologize for the confusion for the starting time. I don't know what happened. I do apologize.
Okay, can I put in a request through you now to have somebody here on the 10th at 9 a.m. because otherwise I don't think it's going to happen given the time.
Yeah, I will reach out to them right now when I get off here.
Thank you very much. I appreciate that. All right, before we adjourn for the weekend, is there anything I need to address?
No, thank you, Your Honor. Not from Ameren, Missouri.
Okay.
I think it's well summed up. I think we all did pretty good here. So everybody have a good weekend going into a holiday.
Well, while emotions. Say that again, Mr. Keeble.
So my witness will be available, Judge, so it works fine for us.
That's fantastic. I appreciate everybody accommodating this hearing here, and I will see you all at 9 a.m. on Tuesday. I will adjourn this proceeding for the weekend, and we will go off the record.
Judge, when your paralegal will be sending out another WebEx connection link thingy?
Yes, I will see that is done by 8:30 a.m. on Tuesday morning.
All right. Thank you.
Thank you.